Let me start the recording. I would now like to open our lecture session. The first speaker of today's section is Dr. Ivano Alogna. He is a research leader in environmental and climate change law at the British Institute of International Comparative Law. He is also an associated member of the Sorbonne Research Institute and in International and European Law in France, and a Glasgow Law Fellow at the University of Glasgow in Scotland. Dr. Alogna will be speaking about corporate climate litigation, new trends and directions. Over to you.
Thank you very much, Larissa. It's a pleasure and honor to be with you and with this great colleague for these workshops. So today I'm going to speak about the title that you gave me about corporate climate litigation, new trends and directions. So for doing so, I have prepared just a short introduction on climate litigation, just to enter into the field. And then I will going to go through a couple of waves of corporate climate litigation. This is something that it is, as you know, quite new. And then a few examples of, in a sort of global overview of this kind of litigation. And then I will conclude with some new direction for corporate climate litigation. This is something about a new project that we are working on at BICL. And yeah, and that's it. I hope that I am going to be short enough, because then I have also to leave soon. Thank you very much anyway for the invitation. So as an introduction, let me start with the object of this kind of litigation. When we are talking about climate change, as you know, you already had all yesterday's work. We generally say that it's an always more evident super weak problem. So time is running out. There is no central authority to tackle it. And those who are seeking to end the problem are also at the basis of the problem. They are also causing it. So notwithstanding the elaborate international climate regime, which I'm sure that you already examined in details, the UN Framework Convention, climate change, the Kyoto Protocol, the Paris Agreement, we saw that the problem is that the states are lagging behind in comparison with the rapidity of climate change. So last autumn, you see on the slide on the top left of this bunch of pictures, the Emission Gap Report 2022 was published. You see that for those who have read, these finds that the international community is falling far short of the Paris goal. There is no credible pathways to 1.5 degrees in place. And so they basically said that only an urgent system-wide transformation can avoid climate disaster. And this is, of course, an always more evident failure by national and international policymakers that has required, in a way, other actors to react, to jump in order to tackle climate change. And therefore, that's why climate litigation is taking the lead in tackling climate change, thanks also to lawsuits in which not only NGOs and citizens, but also activists, shareholders, investors, we are seeing cities and also states, of course, they are challenged local authorities, national governments' actions or inactions. And in this way, as was said by Johnny Lin, climate litigation can be considered as a critical component of the governance framework that has emerged to regulate how states respond to climate change at all levels, at the global, regional, but also the local level. And this is something that is done by exerting pressure on the executive and legislative branches of the government to act on to the climate issues that we are seeing in this first part of the millennia. So at the same time, climate change related cases have also been filed against private actors, which is the topic of my presentation, such as the carbon majors, which, as you know, are the major greenhouse gas emitters. Mostly we are talking about fossil fuel and cement companies. And these were already identified a few years ago. In 2014, there was this very important assessment by Rick Heady and the Climate Accountability Institute that was studying the historical contribution of these companies to greenhouse gas emissions. and Richiedi attributed at that moment 63% of the carbon dioxide and methane emitted between the end of the half of the 18th century and nowadays to a mere 90 entities. So we can understand how we can restrict the number also of entities to let's say discuss with. So just last week, it's quite interesting. Richiedi published a new research in a journal called One Earth. The title is Time to Pay the Piper. And it's quite interesting because it's quantify the economic burden caused by individual companies that have extracted and they continue to extract the fossil fuels, and also highlight that the worst of fossil fuel companies owe at least something like $209 billion in annual climate reparations to compensate the communities that are most vulnerable, that are most damaged by this kind of activities of theirs. So as usual, we have the usual suspects, we can say, that are mentioned. So BP, Shell, ExxonMobil, Total, and Chevron. These are just some of the 21st polluters responsible, according to Rick, and his group, for $5.4 trillion in drought, wildfires, sea level rise, and all the consequences that, all the catastrophes that, are caused by climate change, and that will be expected between 2025 and 2050. So in a way, this is just by saying that scientific evidence is growing, as well as the precision of the attribution science findings that in a way is continue to confirm the causal link between climate change and fossil fuel related activities. And that's why there has been a surge, because this is one of the reasons why we have this surge in climate litigation against fossil fuel firms and many other polluting industries in recent years, with many cases that are challenging corporate inaction on the climate crisis, and also attempt to spread misinformation. We know, for example, there were some companies, they knew about this kind of coming crisis since the 1950s. And so in a way, companies are increasingly recognizing this kind of responsibility, we can say, at least involvement as a risk for them, not only for ourselves. So we will see now how these kind of cases against corporations constitute the basis for new trends of climate litigation and the new direction these ones are taking, or we hope that are going to take. So we must add just the last point, as you see, that last year, for the first time, the IPCC has recognized that climate change litigation can affect the outcome and ambition of climate governance. So this is just to say, and I just put some of these interesting documents to be seen. There is the LSC report from last year. In 1 month, we will have the new one. There is the UNEP report written also by Columbia scholars. And there are, of course, the IPCC and the other UNEP report that I mentioned. Yeah, this is probably most of you already are quite aware of the existence of this, but just to be sure. So when we are talking about climate litigation, we are talking about something that started in the early 2000s. In reality, literature on climate litigation in law and social science is something that has grown steadily in the last 20 and something years. And the development of this body of scholarship has largely tracked the exponential growth that we witness in the number of climate-related cases. So we are talking about a handful of cases already in the 1990s. As of today, there are more than 2,000 cases that are identified in the Sabin Center for Climate Change Law, Climate Change Litigation databases. There is one, as you can see, there is a little bit. The one is just dedicated to US climate litigation, and the other one is the global one. So taking into consideration 45 countries and more than 10 regional and international jurisdictions. So we just have to understand also that this is a US kind of database. So and the reason why is also that in the US, this kind of litigation has been really, really successful in the sense of not really success in terms of results, but really success in terms of its spreading. And so almost 3/4 of the total cases repertoire in these databases are identified in the US. And then we have also another one, the one on the right top hand, there is the one from Australia. Australia is quite important also as a legal system because it has the second largest number of climate cases globally. And this is the database that has been created by the Center for Resources, Energy and Environmental Law at the University of Melbourne. So this has more than 200 cases that have been filed, and there are also cases in Australia, and there are also cases coming from New Zealand and Pacific Island countries. Also a very interesting tool. Another important global database is the database is provided by the Grantham Research Institute on Climate Change and the Environment, so the London School of Economics, and it's even broader in terms of its field, because we are talking about the climate change laws of the world. So it covers both national level climate change laws and policies, and there are also climate litigation from everywhere in the world. This is quite interesting because Sabin Center and LSE, they created a partnership, so they are sharing also findings and cases. Definition of climate change litigation, also this is just ad abundantia. Concerning the definition, in legal literature, we have two main approaches that dominate the debate on the definition of this kind of litigation. So on one hand, we have what we can call a narrow definition, according to which climate change litigation only covers litigation which directly and expressly raise an issue that is related to climate change or climate change policy. And this is an example of this kind of definition provided by a very often cited definition by Marker and Rule, two American professors. On the other hand, we have broader definitions. I would say there are more than ones. I just put an example from Jackie Peel and Johnny Lin article. So the broader definition are, I should say, increasingly put forward because in addition to the explicit reference to climate change in proceedings, decisions, they also consider the motivation of plaintiffs, as well as cases where climate change is not really the central, but rather an additional or secondary concern, and even when it's not expressly mentioned. And it is quite interesting because this kind of broader definition is especially required when we consider climate litigation, for example, in the Global South, because in a way there are many legal systems in the Global South where there are a significant number of cases that reflect these, as I said, peripheral focus on climate change, and they don't have really climate change laws. Maybe they don't have the issue at the core of the litigation. So it's quite important to see also from this kind of broader perspective in order to examine substantially climate change everywhere. This second kind of distinction is proposed by Professor Wellen and Tran. So they do this distinction between vertical and horizontal climate litigation. So we arrived to our kind of litigation of today. So vertical climate actions, generally they are NGOs that are going against a state, generally fall under public law. They are brought before the administrative constitutional courts. The state's protective duties concerning fundamental and human rights, as well as obligation under international law arising from any kind of international agreements, constitute their standards of review. On the other side, we have what we call what they call horizontal actions that are between private individuals and companies, and they are brought before civil courts and typically have tortious basis for claims. So fundamental and human rights have also an indirect horizontal effect in these cases. And of course, there is the interpretation of general clauses and open elements of tort law, for example, la faute in France, or unlawfulness as another element. But these fundamental human rights are used to further develop the private law by establishing new duties of care towards third parties that are intended to protect the climate. And this is something that we will see in the cases we're going to share. So for the waves of corporate climate litigation, we see two basic waves. So in the first wave, the most exposed sectors were carbon-intensive industries. They were the one responsible, they are the one responsible for generating high levels of greenhouse gas emissions. The majority of those cases were brought under the law of tort in the US. So this is really, it was a little bit US-centered, this first part, we can say. The claims failed in this first wave, most of them, principally because of the difficulty, as a matter of fact and law, of establishing, as I said before, the causal link between the particular emissions of the corporation and the climate change impacts. When it comes to climate litigation in the private sector, I imagine you know much of the literature, much of the commentary to date has tended to focus, as already mentioned, on cases against these carbon majors. Kim Bauer critically discussed this kind of litigation as the holy grail of climate litigation cases. And let's say that given these companies' historic, current, and also future contribution to emissions, hopefully not that much, these cases are today considered really fundamental. That's why we are also working a lot on this vehicle. This first phase, as I said, included some of the very first cases brought against corporations, notably including the village of Catalina versus ExxonMobil, that was in 2012, by states also against utility companies, like, for example, the American Electric Power Association versus Connecticut, that was the year before in 2011, and also against automotive companies. And this was the case, for example, of California versus GM, that was in 2007. So we go backward. Many of these initial cases, as I said, failed under the political question doctrine in the US, or were preempted by federal statutes like the Clean Air Act. The second wave, the one that starts after the Paris Agreement, we can say, the targets for climate litigation extended beyond the carbon-intensive industries, in addition, of course, to the continuing trend in cases concerning a company's contribution to climate change through their greenhouse gas emission. Other types of claims against business, various and in different sectors, and start to emerge, as I was saying. So we are talking about claims concerning director duties and companies' obligation to disclose the financial risk of exposure to climate change. And these are generally brought about by their business activities. Also, the evolving landscape of litigation against government is keeping triggering, in a way, further legal and policy changes, which in a way continue to have a sort of ripple effect across the private sector. A landmark example that we are going to see in a few moments, and the only successful so far, the only successful case of this kind of litigation is the famous Milio Defenses versus Royal Dutch Shell in the Netherlands. As you know, here we have Royal Dutch Shell, that is Europe's largest oil and gas business, at least by revenue, and is a giant who has operations in more than 70 countries. That was sued that was April 2019 by this environmental group, Friends of the Earth, Netherlands, Milio Defensie, together with other NGOs, and together with 17,000 Dutch citizens. And they were alleging Shell's contribution to climate change violates its duty of care under Dutch law and the human rights obligation of business and enterprises. We will see this in the next slide. So in the last year, we are also witnessing to an always more important extension of corporate climate litigation to new areas, new challenges, as I wrote here, and what we can call an always more creative use of different causes of action and legal strategies. Higher emitting sectors continue to be, of course, the most exposed to transition risk, including climate litigation and related legal and policy risk. Those sectors include, of course, energy and natural resources, industrials and infrastructure and constructions. For example, companies in the industrial sector, particularly those in manufacturing, which engage in carbon-intensive activities, are exposed to climate-related claims, seeking to block new projects or expansions from going ahead. Usually, the idea is to seek an injunction or a declaration that the project in question is unlawful. Carbon-intensive project proposals that fail to address climate impacts and respond to sustainability concern also could face not only litigation preventing their development, but also, as you can imagine, they face the divestment of capital from lenders, from investors, and something that we understood also thanks to the Paris Agreement, a reputational damage. So high-profile cases against corporations are also talking about new areas involved in food, in transport, and in finance. And they have all made mainstream media headlines in recent months. We have a new report from LSE just came out this morning. It's talking also about this and these new trends. Trade publication, for example, for the, as I was saying before, the automotive industry are starting to publish pieces on how litigation could shape the future of their sector. So they are really aware of this risk and of the consequences of corporate climate litigation. And climate change also has started to become recognized as a financial risk, which should be disclosed and addressed in the risk management strategies of every business and everywhere in the world. This is something that we will see is really quite important. Concerning the energy and natural resources sector, which is, as you can imagine, quite important, is the main part. This recognition has also led to an increase in claims brought by shareholders and investors against companies for failing to properly disclose or manage the financial impact of this climate-related crisis. And its risk, of course. Let's go just through a very short global overview of corporate climate litigation. As you know, in this moment, we have really hundreds of cases around the world. And this is something that, in a way, is keep improving or enlarging or spreading everywhere. So we see also a certain circulation of ideas that we see coming from the US, going to Europe and other part of the world. So I just took 5 cases that are really too important not to mention. But for the American, as I said, they have hundreds of cases, and this is just an example. This is the one of the City of New York versus Chevron Corporation. So New York City filed a federal lawsuit against the 5 larger investor-owned fossil fuel producers, and the idea is to seek the cost that the city had incurred and would continue to incur to protect itself and its residents from the impact of climate change, so an adaptation kind of cost. The city alleged that the 5 defendants should be responsible for this cost, as they were responsible for over 11% of carbon and methane pollution, and had downplayed, and in this I think there is also much of this kind of work that I was mentioning at the beginning from HICIDI and the Climate Accountability Group. So this is something that is really fueling this kind of litigation. So they were, as I said, downplaying a little bit the risk of climate change, and also they continue to promote the use of fossil fuel despite the risk that we are all witnessing. So the city basically claimed that the defendants' action constitute an unlawful public and private nuisance, so talking about the different causes of action, and an illegal trespass on city property due to sea level rise, because as you know, New York City is there. So in July 2018, the US District Court for the Southern District of New York granted a motion to dismiss filed by the defendant companies on the basis that the federal common law governed the city's claim because they were ultimately based on the transboundary emission of greenhouse gas emission, and require a uniform standard of decision. So in a way, they always try to push toward other kind of legal basis. The court also reasoned that the Congress had expressly delegated to the EPA, to the Environmental Protection Agency, the determination as to what constitutes a reasonable amount of greenhouse gas emission under the Clean Air Act. And so the city's claims were displaced by the Clean Air Act, as I was mentioning before. And lastly, the court found that New York's claim represented non-justiciable political question, as the claims would severely infringe, they say, upon matter within the purview of the political branches. Always this problem related with the separation of powers. So the city, of course, filed an appeal to the US Court of Appeals for the Second Circuit. That was in 2018 in November. And they urged the court to reverse this dismissal and to hold the companies liable for climate change impact. Unfortunately, in April 2021, the Second Circuit affirmed the dismissal of the city lawsuit, largely following the reasoning of the district court and concluding that the state claims were preempted by federal law. So this is really one of the main problems that we have in the US. Then we go back to the Netherlands. As I said, this is the only successful case that we have in this field in the world. So quite important is to mention a little bit what it's about. The Shell case was brought in May 2021. The Hague District Court, so we are the first level, ordered Shell to slash its emission by 45% by 2030. And this always using the 2019 levels. And the interesting thing also is that they ordered to do this across both emission from its own operation and emission from the use of the oil it produces. So in March 2022, of course, Shell appealed the decision. So now the case, as you know, is pending. However, the court has declared orders to be provisionally enforceable, meaning that Shell will be required to meet its reduction obligation, even as the case is under appeal. And this, in a way, landmark ruling sets a precedent that corporation can be held liable for an inadequate action to curb climate change, as must cut emission in line with global climate goals. It may well also usher in a new era involving climate litigation. This is what we hope. And hopefully, it's going to fuel more climate suit targeting corporate emitters. The focusing issue of this case is whether a private company would be held liable and violated its duty of care and human rights obligation for, as I said, inadequate action to curb contribution to climate change. So this case, as you know, built on another Dutch landmark case, the Urgenda decision, which in 2019, before the Supreme Court, found the Dutch government's inadequate action on climate change violated a duty of care to its citizens. But in this case, in these suits against Shell, the plaintiffs extended this argument to private companies, arguing that given the Paris Agreement goal, and as I said, also the scientific evidence regarding the danger of climate change, which is becoming always more evident, Shell has a duty of care to take action to reduce its greenhouse gas emission. So the plaintiff outlined how Shell's long knowledge of climate change, misleading statements to an inadequate action to reduce climate change helped to support a finding of Shell's unlawful endangerment of Dutch citizens and action, and so it constitutes an hazardous negligence. This is quite interesting because this is something that everywhere in the world is trying to replicate, but in a way it's quite difficult because the court interpreted something particular, is an unwritten standard of care that is part of the Dutch Civil Code. So you can find this as an obligation found that you will find in section 162 of the Civil Code, which means that Shell acting in conflict with this, what is generally accepted according to unwritten law, is unlawful. So any company, not just Shell. So its content is, of course, also informed, as it was for Urgenda, by Article 2 and 8 of European Convention on Human Rights, which guarantees, as you know, rights to life and rights to private life, family life. And the court's interpretation is based on the relevant facts and circumstances. As I said, the best available science on dangerous climate change, how to manage, and the widespread international consensus that human rights offers protection against the impact of dangerous climate change. And of course, the company must respect human rights. The third case is, as you know, last May, it was 1 year ago, a publication by the Commission on Human Rights of the Philippines, is the final report of this commission on the responsibility of the carbon majors for climate-related human rights harms. This is a proceedings that was launched in 2015 after typhoon survivors and civil society groups filed this petition asking the Commission to investigate the relationship between human rights, climate change, and the responsibility of carbon majors. They called for a probe into the possible human rights violation. So we are talking about loss of life, livelihood, property in the Philippines. So we reconnect to the Articles 2 and 8 of the European Court of Human Rights. And this is something that was aiming the 47 biggest fossil fuel and cement companies that were the basis of climate change. So the final report concludes that climate change is a human rights issue and also affecting the individual rights to life, food, water, sanitation, health, and also the collective rights to food security, the rights to development, self-determination, preservation of culture. There are so many aspects that are touched by climate change, as we know, and that were touched upon by this decision, by this report, let's say. While at the same time they were impacting vulnerable population, you can imagine in this kind of context, including women, children, indigenous people, and the rights, of course, of future generation. And this is also was highlight how this role of companies and climate change, human rights, climate change, being a major cause of migration and threaten global security. So the report was is quite interesting to read and demonstrated that these 47 of the world's biggest oil mining coal firm, they engage really in a sort of obfuscation of climate science and block a global transition to clean energy. And yeah, and that's it. I think this is really already giving a quite grim kind of picture. I will mention the last two as two very interesting cases ongoing, and they are always corporate climate litigation cases, but with a transnational kind of dimension. So the first one, the Luciano Luya versus RWE, has been brought by this Peruvian farmer, Saul Luciano Luya, in 2014, against the Germany energy company RWE for its contribution to climate change. So this seems a little bit weird. At that time, it seemed crazy. Now makes sense. So the claimant that were supported by the NGO German Watch argued that climate change is causing glaciers near his farm, in Huaraz, which is in Peru, near the mountains, to melt, which will result in flooding of his community. And according to Luciano, RWE's contribution to climate change and the related flood risk amounts to unlawful interference with his property. So Luciano Luya demanded the court to order RWE to pay their share of the adaptation cost to help protect his community from floods. So it's not much if you consider, but it was something like $21,000 as a sort of financial contribution for building defenses against glacial lake flooding, landslides, and of course, a possible inundation of this village. And as we said, the destruction of this property. And in this case, we have a court of appeal in Germany, the Civil High Court in Hamm, that determined that this case is sufficiently strong, was sufficiently strong to be admissible. And as it was based on the carbon major research that I mentioned before, which traced back to LWE the precise amount of 0.47% of the overall CO2 emitted in the atmosphere during the industrial era. The case also, again, is a case that is based on the civil code. In this case, on the German civil code, is based on the general nuisance provision of the German civil law code. So is the paragraph 1004 of the BGB. And to conclude, a similar transnational climate-related cases is the Four Islander of Paris versus Orling versus Holcim, which, as you know, another very important cement company. In this case, we have 4 inhabitants of an Indonesian island of Paris that were supported as well by 3 NGOs. So we have, they have sued in July 2022, so a few months ago, this company based in Switzerland, and they filed a request for conciliation before the Justice of Peace of the Canton of Zug in Switzerland. This was a necessary step required by the Swiss Civil Procedure Code. What they ask, the plaintiffs request concern proportional compensation for climate change related damages on Paris, reduction of CO2 emissions by 43% by 2030, comparing always to 2019 levels, and financial contribution to the adaptation measure on Paris. Unfortunately, we see last February, the request for conciliation didn't succeed. So the plaintiffs announced that they have formally lodged lawsuits against this, against Holcim and its role on climate change. And this claim, I conclude with this, can be really seen as an unprecedented kind of case because it combines different approaches. There is the reduction of greenhouse gases, there is compensation, and the plaintiffs are also demanding the company co-finance adaptation measures on Paris, such as mangrove plantation, and in a way that's this company also pays loss and damages for its role in the climate crisis. So a very interesting case to be followed. I just conclude my presentation with this new direction for corporate climate litigation. I mean, I strongly believe in the role that the scholarship might and should play in providing ideas, in analyzing possible avenues to improve this kind of field. And I think that it's really quite important, the cooperation and discussion with experts coming from every part of the world. So in this sense, at BICL, we are working on this new project that is called Global Perspective on Corporate Climate Legal Tactics. You can go on BICL website. Last week, we had a very interesting conversation with great experts. We did this webinar. You will find the recording on BICL website. The idea is to produce a global toolbox on corporate climate litigation. And in a way, the goal of this project are to produce a mapping and a comparative analysis of corporate climate litigation globally. And we start this year by taking into consideration perspectives from 17 countries in every continent. The idea is to offer a comprehensive overview of both the existing best practice worldwide and also the most suitable corporate climate legal litigation avenues for very differentiated, as we know, legal system and economies. This project will catalog existing cases. So we are taking stock of the lesson learned in other fields like tobacco, asbestos, toxic thoughts, and many others. And we are trying to engage in what might be considered strategic, prospective, and certainly also interdisciplinary thinking, because each national rapporteur, as I said, we have 17 countries, will take advantage of workshops, discussion with other legal scholars of its legal system and practitioners within different fields of expertise. Also, we ask them to consult with judges, with scientists and economists, and we try to, in a way, identify possible frameworks, arguments, and legal instruments to tackle climate change. As I said, until now, we just have the shell case that have been successful, so we have to try and push a little bit the boundaries in this sense. And to finish, the project aims to help also litigation planning. The idea is that it contributes to more comprehensive, effective climate action, and maybe raise public awareness, and eventually, as a consequence of its deterrent effect, allow and encourage corporate actors to mitigate their litigation risk by changing business behaviors. So in view of these objectives, the project which will provide this selection of tools, that's why we call the toolbox, that NGOs, government bodies, local communities, and many other affected groups around the world will use for this kind of litigation, and also contain an inventory of substantive and procedural provision related to climate change cases to be used in a way as models by policymakers and legal practitioners, and also hopefully act as an authoritative reference point for judges, why not, and many other adjudicators. So I hope that I wasn't too long. I stop here, and I thank you for your attention. I really apologize for the fact that I have to leave you now, but if you have any question, please do not hesitate to contact me via email. You have my email here in the first slide, and it's e.alogna@bicol.org. So thank you very much for your attention.
Thank you so much, Ivano. I will be sure to post your email in the chat as well if anybody wants to contact you specifically. Someone in the chat has also asked for the link for the CCL Toolbox project, and I've placed that in the chat for everyone to see.
Perfect. Thank you very much.
Thank you once again, and have a great day.
Thank you.
Bye. Carlotta, over to you to introduce our next presenter.
Yes, thank you, Larissa. So our next presenter is Catalina Vallejo Piedrahita, that I think joined us already, from Medellin. Catalina is a qualified lawyer in Colombia and a professor of international law at the EAFIT University. She holds a master in peace studies and a PhD in climate change litigation, on which she has researched extensively, as well as on the field of rights of nature. She has authored recently a publication on the quest for butterfly climate adjudication, on the role of low-profile climate change cases, as well as she's worked on rights of nature in Colombia and other countries. And today she will talk about the intersection between these two topics, climate litigation and rights of nature. Over to you, Catalina.
Thank you, Carlota. Carlota, can you hear me well? And can you see me? Yes. Okay, wonderful. Thank you for this invitation. I'm very happy to see you, Carlota, and hello to Larissa. Well, we've been exchanging some emails. Okay, so I'm going to share my screen. Okay, just a second. I always get a little bit confused with my different screens here in the computer on my laptop. Larissa, is it okay if I ask you to share my slides?
Of course,
Please. Thank you so much. So I don't get too confused here with this. Perfect. Then I'll start. So today I would like to share with you a little bit of my journey really with climate change research, climate change litigation research. So I started my PhD around 10 years ago. And since then, I think I've been through different phases of hope and hopelessness with climate change. And in the recent years, I've been studying the rights of nature. And I've been surprised by realizing that it's very different, but very interconnected and very even similar kind of strategy or movement to litigate nature protection and human rights protection in a new way or in a different way, but it interacts really well with climate change litigation. So I'm really honored to be here today to address really what is one of the greatest challenges humanity confronts nowadays, the urgent need to reduce greenhouse gas emissions, implement effective and equitable measures to adapt to the consequences of planetary atmospheric pollution, and in general to advance strategies to protect nature, including ourselves, of course, from human-made environmental decay. And today, especially, I would like to bring your attention to two innovative legal strategies. On the one hand, climate change litigation and the recognition of rights of nature. These approaches have emerged as powerful tools in our quest to protect nature, including ourselves, from harmful consequences of environmental degradation. Both climate litigation and the rights of nature concept are disruptive, legally disruptive in nature. They challenge conventional legal norms and pave the way for radical new approaches to legal argumentation in the face of the socio-environmental crisis that we are in right now. So the slide you're seeing right now, I would like to start by sharing that there are at least two ways in which we can approach this climate, and this is very connected to my personal journey. The first, I think, is to have a very clear pessimistic perspective. Every time we see new IPCC reports or the news now that we see that 1.5 is kind of around the corner, it's very likely, and the more we read law, philosophy, science about climate change, I think, at least is my experience, I don't know if I'm alone in this, but it's very possible to think that we're doomed, that there's nothing we can do, that it's already too late, or to have a view on humans as really like a pest, and everyone will be better in the planet if we are extinguished, and this kind of very negative sensations, feelings. And the other one, it's of course to have a more hopeful perspective perhaps, and not to be naive, but to think that, okay, we have been able to live in this planet for many, many centuries. And it has been possible to have more harmonious relationships with nature. And there is the traditional and ancestral wisdom that we still have with us. And also we have now science. We have also science, and we know many useful things, no? And we have also developed very interesting legal tools. So even though it's hard for me, I've been trying to stay in the second path, also because I work as a professor at the university. I work with young people. And I, of course, need a little bit of hope myself to stay working and thinking and be creative. But also, I think really there is not much good or interesting things we can do if we follow the very, very negative perspective. And I think the reality of climate anxiety in younger people is very clear. Yeah, exactly. So in this pursuit, I am trying to stay hopeful, and so that's why my work tries to look at what has been working in climate litigation, and also pay very close attention to what has been problematic so far, also the shortcomings of climate change litigation and rights of nature, and to think about the problems we have to confront and that we need to think clearly about. Yes. So if we can go to the next slide, please. And so there, in my research over 10 years on climate change litigation, I found that there are, of course, many ways to litigate climate change using constitutional rights, international law, using claims for damages, administrative regulations. Climate cases create spaces within existing law to include climate change concerns into the adjudicative practice. So we can have strict climate law cases designed to argue climate change mitigation and adaptation exclusively, but also we can find space within other within other ramifications of the law or other branches of the law, different branches of the law, to include climate concerns. At the core, all climate change cases discuss the duty of governments and private actors to take precautionary measures to avoid the accumulation of greenhouse gases in the atmosphere and to protect us from the negative impacts of what already is accumulated. People increasingly are going to courts to hold governments accountable for climate-related responsibilities, and courts have responded, including by calling governments to self-restraint in relation to previously unquestioned activities that cause climate change. So my research has really focused on administrative and constitutional law litigation, challenging states over the responsibility to protect us all from climate change. We go to the next one, please. So what I want to present today is the idea that echoing Catherine McKinnon's book, Butterfly Politics, where she, as a feminist legal scholar, argues that seemingly insignificant actions through collective recursion can intervene in unstable systems to produce systemic change. And she says that seemingly minor interventions in the legal realm can have a butterfly effect that generates major social and cultural transformations. And similarly, the bottom-up, I think that similarly, the bottom-up regulatory regime created by the Paris Agreement has the potential to lead domestic courts to do butterfly climate judging. And rather than waiting for the perfect international treaty on climate change that is that has clear responsibilities for all states and that we can measure how we are improving, how hold states accountable internationally. Instead of waiting for that perfect treaty to tackle the climate problem, courts so far, as I see, have accommodated existing legal norms and doctrine to novel climate issues, creating important precedents from which a climate jurisprudence is evolving. So although climate change has been considered too abstract and too speculative for courts to handle, existing legal frameworks are adapted to accommodate and even mainstream climate change in routine decision-making. And I'm thinking about routine administrative decision-making and constitutional decision-making, especially. But I think that it shows also in contract law and commercial law as well. While still diverse, uneven and produced in different legal systems, court interventions, we should not overlook the contributions of this emerging jurisprudence to transforming the collective action problem that is climate change. If we go to the next one, please. So if we focus on progress, some progress we've made so far, since the early 1990s, when the first cases were brought to court, climate jurisprudence has developed from rejecting almost all climate claims because they were speculative to nowadays using variously the IPCC reports to prod governments into making better informed decisions, including on fuel efficiency standards, greenhouse gas emissions from coal power plants, licenses for extractive projects, airport expansions, housing projects on coastlines endangered by sea level rise, deforestation policies, climate mitigation targets, industrial use of water sources when climate resilience is at stake, and market incentives for renewable energy projects, among other developments, especially in the recent years. Human rights arguments and human rights cases have really taken a lot of strength, and the connection between climate change and human rights is today almost impossible to argue. No, it's very, very, very evident, very clear. So those are very, very important steps. With the use of IPCC reports as legal proof, judges around the world find ways to establish case by case what type of legal problem exactly climate change is in a given moment and space. For example, if it is a human rights problem or a problem of atmospheric pollution or of inadequate environmental impact assessment or a problem of sustainable development or biodiversity protection, equity with future generations and other species, a problem of rights of nature, or a problem or market failure for renewables, just to name a few. More than that, by setting the debate about the validity of climate science in public decision-making, courts have established climate change as a collective action problem that requires regulatory interventions from the state. Some courts have expanded the meaning of notions such as pollution, for example, what happened in the famous EPA case in the US, and development planning to make them workable for climate change. So what I'm saying is the courts have used good old legal doctrine and notions and concepts to they have adapted them to work for a specific climate problem they confront in a case. While litigation is not panacea by any means, of course, the role of social mobilization is so important. Of course, economic debates are very, very central to this. Of course, planning, engineering, biology, and different disciplines are all super important. I've never really thought that litigation is the solution or the one solution to everything, and not to climate change for sure. But I do think that together with other strategies and work in many fronts, it really, really can be, and it's so far has been a very powerful tool. And through perhaps connecting to the butterfly effect that Catherine McKinnon saw or observed for feminist mobilization, the cross application of precedents or decisions from one country to the other, as we all share similar issues. So the cross application of precedents through that, climate jurisprudence can make small, simple interventions, as McKinnon says, into political systems and eventually contribute to system-wide changes. If we move to the next one, please. However, there are also important shortcomings in climate litigation so far. However, the progress we've made, the jurisprudence still falls short in different ways. It struggles to take sustainable development seriously when faced with economic arguments, and I think this is a major issue we still have. And while accepting climate science and the human rights risks involved, many courts still find that existing domestic policies are good enough or within the government's discretionary power. This is the notion of discretionary decision making and in administrative law, I think, is still very much untouched or widely untouched, while I think a bit more space for judicial review of administrative decisions concerning licensing, for example, of extractive industries or extractive activities. It's a field that we should be making more progress on. The jurisprudence has also centered mainly on rights declarations and norms violations, failing to provide remedies or better remedies, and failing to monitor to create monitoring mechanisms to improve compliance with rulings. There are still few signs of democratic experimentalism and participatory implementation of solutions, which could encourage the cooperative relations among branches of power needed to address super wicked problems like climate change. So I think, for example, the experience we have in Latin America with dialogic constitutional law and with the creation of monitoring mechanisms for the courts to keep their competence to still to do follow-up of their decisions, which in Latin America it's very much needed, because we have perhaps, to protect human rights, we have better protection from the judiciary than from the executive branch, or from the congresses as well, from the political branches. So we have developed these interesting ways for courts to be able to push the political branches without necessarily stepping into their work, but being very clear about their role of judges in protecting human rights. So the protection of human rights and judicial review of administrative decisions, it's kind of saved us from power abuse many times in Latin America. And I think this is one of the experiences that can be shared and that can be also used in climate litigation in other continents as well. If we go to the next one, please. But despite these shortcomings, I would like to mention specific progress in case law. So I'm going to mention like one by one line. If you can click, please, these lines. Courts are overcoming fundamental barriers to dealing with climate change. So as I said before, by using IPCC reports as solid proof, they have overcome the challenge of uncertainty over the existence of climate change and the risks it poses for human rights. We know that while still in some places in the world, the executive branches, the governments insist in denying climate science. What I found in my research, and I'm sure all of you have seen the same, is that the judiciary has been very clear for over 2 decades about the fact that it's impossible to discuss climate science. So they have overcome the challenge of uncertainty. Even where governments deny climate change, the judiciary significantly does not. They have also dealt with the drop in the ocean argument, the very famous idea that one change in a license of a coal power plant is not going to change the world, is not going to stop climate change, and the idea that one decision by a government is not going to change everything. Therefore, this decision is not necessary. But judges have acknowledged slowly, but now surely, the cumulative nature of both the causes of climate change and potential solutions to climate change, concluding that in complex global problems, all contributions matter, and then pushing governments to do better. Thanks to these analytical advances, courts have created important precedents that can be used in other courts confronted with similar cases. And now these are the different, just a set example of different precedents around the world. For example, establishing that greenhouse gases are pollutants subject to state regulation, like it happened in the US Supreme Court in Massachusetts v. EPA in 2007. And the next one, please, including climate change risks as mandatory requirements in environmental impact assessments of carbon-intensive projects. This has happened in courts in the UAE, Australia, South Africa, and I wish it happens very soon in Colombia and other Latin American countries. I think I really have a strong hope in this way, in this line of argumentation, that we need to change the regulations we have for environmental impact assessment, and we need to include the obligation to account for carbon emissions and compensation of carbon emissions, and we need a very detailed explanation of scope 1, scope 2, scope 3 emissions. So we will also improve accounting and planning for climate change. And within this, I think there's also space for the inclusion of biodiversity protection in environmental impact assessment, including new aspects. For example, and here I connect a little bit with rights of nature, for example, including the harms to not only animals and plants, but also what happens in the soil underneath with fungi, for example, and how this very complex system of interconnection of fungi is very harming to our ecosystems. And that so far, at least in my country, when I'm studying this, and as far as I know from my colleagues in most countries, is not included in biodiversity laws or conservation laws, and for sure not in environmental impact assessment regulations. And the third one, please, establishing climate adaptation, or the idea of climate resilience as a consideration in planning for development of carbon intensive projects. This has been said in Australia, also by Colombia's Constitutional Court, by India's National Green Tribunal, and the Supreme Court of Pakistan, at least until 5 years ago. And I'm sure now that we find more cases where adaptation is considered a serious issue in planning regulation and planning law, adaptation to climate change, which before didn't really exist at all. The next one, establishing that governments must implement existing domestic climate laws and policies, so that it is not enough with creating new laws on climate change mitigation and adaptation, but also the governments need to implement them, and citizens have legal tools and mechanisms to push the governments for that adequate implementation, needed implementation, including budgetary decisions, including the creation of new institutions if that is necessary, including the creation of new legal mechanisms as well, for example. The next one will be establishing that citizens have a right to free access of environmental information, including on the climate change impacts of public fund investments. This one is really important. We know that we have international treaties to protect citizens and give us the right to access environmental information, but this is one of the most difficult rights to protect. And we know that most human rights defenders around the world that have been killed or threatened in the last years are precisely environmental defenders. This is the case in Colombia, this is the case in Brazil, this is the case in the Latin American countries, and this is a trend. So opening up access to information, opening up the transparency of states in sharing information about investment from public funds, where is the money going? Where is the money from of pension funds, for example, public banks? Where is this money? Where are these investments going? We don't really know where our money is when we have our savings in the bank. And it's mostly going to carbon intensive projects, and it's mostly going to the weapons industry as well. So I think this has been a very important step that we, that this is thanks to climate change litigation, but we still have a lot of work to do in that regard. The next one will be establishing a governmental duty of care for climate change, which has been, of course, huge and so important. And we have to thank our colleagues in the Netherlands, the Urgenda Foundation, really this 2015 ruling changed the game of climate change, at least in relation to holding governments accountable. No, so just now having clarity over the fact that there is a strong connection with human rights and that governments have a main duty to care for climate change, and if they are not ambitious enough, if they are not serious enough in their policies, this can be considered a violation of governmental duty of care. This is very important. The next is declaring state incentives for renewable energy as legitimate policy objectives. No, so when when there is competition and governments provide incentives, special incentives for the renewable energy industry, of course, the non-renewable energy industry may be feeling that competition laws are being violated. But judges saying that declaring these incentives is a legitimate policy, that the government has a right, or yes, has a right to decide where where it wants things to go, in which direction to direct policy, no, to establish a direction. It is legitimate. This is something governments can do. This has been a very, very important support from the judiciary. The next one will be declaring that deforestation violates the rights of children and future generations, like happened in the Amazon Future Generations case in Colombia in 2018. We have had a massive problem with deforestation for decades, connected to many different issues, no, to lack of control and planning from the state, also to the presence of an armed conflict in our territory, but connecting deforestation with the violation of children's rights and future generations, and establishing a clear argument for state protection and special planning and special protection and planning also has been really, really important, although deforestation hasn't really stopped or even decreased after this ruling in Colombia. Setting an ethical path and setting a moral and political and legal path, establishing what governments should and shouldn't do, it's very important. And lastly, declaring states' commitments under the Paris Agreement as valid reason to deny state permits for airport expansions, for example, like happened in England, although these cases, when they have been, or in Austria as well, but when these cases have been appealed, then the decisions haven't been favorable to the petitioners. However, I think bringing up and having first instance court to decide that airport expansions might be very problematic in a context of planetary climate change is very important. And if we move to the next slide, please. I think, so we see that there are different kind of arguments brought by the courts, and there are different precedents that can be cross-fertilized in different countries using different arguments, but having similar issues. And we see that there are like spectacular and spectacular cases, and this is what Carlota referred to when she introduced me, that I've been studying the role of like non-spectacular cases or low profile cases, because what I see is that most judges do not decide cases in spectacular ways or in precedent-breaking ways, or treat climate change as an exceptional legal problem. Although in the last maybe 5 years, I think we can start perhaps, I don't know, I'm also open to observations of more, yes, more spectacular cases now being successful in court. and climate as an argument becoming more exceptional. But I think the majority of cases, as far as my studies concerned, have been managed in a low profile basis. And so what judges have done is they have used good old law and concepts and doctrine and legal and regulations to include here and there climate concerns. And I think by doing that, they have been normalizing, or they have helped normalize climate adjudication, and they have helped making climate adjudication routine as well. We know that for judges to deal, when these cases are too famous for judges to deal with the press and with the possible idea that they are abusing the law, or that these decisions are too in the realm of politics and not judicial, then they may find themselves in a very uncomfortable position. Of course, they have a career to care for, and they have a name, and they have a family. I am not all the judges want to be in the spotlight all the time. So I think this has been an interesting strategy that the judges have used, and this has allowed for a quiet but very powerful, perhaps butterfly effect, when they make smaller judgments here and there in planning law, in judicial review, in human rights argumentation. And by doing that, they start creating a special climate change jurisprudence. And the next and last slide, please, is about the connection with the rights of nature. So what I see here, so in rights of nature, there are different interesting discussions. If we go to the next lines, please. For example, if nature should have standing in court or not, if we can connect, if the anthropocentric perspective goes against or is the opposite of an ecocentric perspective. But then what happens with human rights, indigenous rights, collective rights? Can we include ourselves, humans, within the ecocentric perspective? So there are very interesting debates happening there, very, very closely connected to climate change. And we see here a map where it's over 100 places, countries where there have been either rights of nature laws or rights of nature petitions or rights of nature initiatives in some way. And so the conclusion is that both climate change litigation and the rights of nature concept are disruptive in nature. So of course, rights of nature is another way, or it is one of the possibilities to do climate change litigation, but it really is it really brings forward a different way of thinking about our relationships with nature, with the idea of development, with like caring relationships, or it really makes us confront our most the core legal concepts, or the legal pillars of our decision-making process, especially administrative decision-making. So both climate change and rights of nature challenge conventional legal norms and pave the way for radical new approaches to legal argumentation in the face of the crisis we find ourselves in. And so my call today will be for us to dig deeper into these two frontiers of legal advocacy, recognizing both their potential to shift our mindset from anomia or despair or extreme negativism or pessimism to a realm of thinking and observing new possibilities in human relationships of care, including with nature. Yet at the same time, let's remain vigilant and committed to addressing the challenges and shortcomings that accompany these strategies, and let's stay creative and think about ways to overcome them. Thank you very much. And I think now we can move to the very last slide. The next one, please. And one more, where you can find my email address, and I would be very happy to get in touch with anyone who's interested in debating these cases. Thank you very much.
Thank you so much, Catalina, for such a comprehensive presentation, and also for contextualizing it within your journey in the research and what keeps you motivated. I think that's very helpful and also relatable for many of us. And we go over to the next speaker, that is Professor Danielle Andrade Moreira. Danielle is a professor of environmental law at the Pontifícia Universidade Católica of Rio de Janeiro, and the vice president of the Institute of Law for an Healthy Planet for the southeastern region of Brazil. In 2018, she has co-founded, together with students and researchers from PUC-Rio, a research center on law and justice in the Anthropocene, and in 2021, they have launched the first platform on climate change litigation in Brazil. Professor Moreira will give us an overview of climate litigation in Brazil today and about how it could develop in the future. Over to you, Professor.
Thank you so much, Carlota. Good afternoon to all of you. Good morning to those like myself are just beginning the day. And that's why I have this strange voice here now. But I have to say that I'm very happy to join you in this super interesting workshop. I'm happy to meet, even if only virtually, Larissa, and also to have the chance to see Carlota again. And I'd also like to congratulate you both and all the team involved in the organization of this event. Thank you so much for inviting me to be here today. I would like to begin apologizing for my limitation with the language, but I have my notes here, and I hope, I'm sure I'll do my best. I hope I can express myself the way I want to, okay? Well, I'm here. I will share my screen. Please let me know if you can see it. It's okay. Thank you so much. Well, I'm here to talk with you about the state of climate litigation in Brazil. I have 30 minutes, okay. And to reflect about some perspectives for the near future. And this is the roadmap for our conversation. We'll start talking a little bit about some of the Brazilian climate cases, especially considering the increasing number of cases issued after 2019. Then we'll talk.
Professor Moreira, I'm so sorry to stop you, but the presentation seems to have stopped just in the PowerPoint. I'm not too sure if I'm the only one, but I'm not seeing the full slides.
Let me try to share again.
No problem.
I hope it works.
If it doesn't, I do have your presentation open in front of me. So.
Let's see now. If it doesn't work, I'll ask you to. Is it working now?
Yes, now it is.
So the roadmap is here for you, okay?
Exactly.
Yeah, thank you so much. Thank you. So we'll start with this Brazilian climate cases, with this overview, especially considering this increasing number of cases issued after 2019. Then we'll talk a bit about climate litigation, how climate litigation is related to the environmental litigation in Brazil, trying to answer this question, if Brazil is a fertile ground for climate litigation. And after that, we'll talk about the main traits of climate litigation in Brazil based on the cases included in our platform that, as Carlota said, was launched last August. And to finish, we'll try to list a few trends and thoughts for the development of climate litigation in Brazil in the near future. Well, to begin, it's important to analyze the climate litigation movement here in Brazil in the context of environmental litigation in general. That is because especially cases issued before 2019 are typical cases related to the protection of the environment. In these previous cases, the climate issues is mentioned mostly in the decisions, not in the petitions, and only in a peripheral way, or an indirect or non-decisive way. We can say that these cases weren't filed as climate litigation cases, but as environmental cases in which climate concerns were mentioned together with many other environmental issues. Here we can see some examples of recurrent issues present in judicial decisions in these previous cases. So protection of mangroves, coastal zone, and beaches, which are among the most affected areas by climate change, cases related to sugarcane straw burning and forest firing, in which climate change is mentioned in the context of air pollution, cases concerning water pollution and water crisis, in which the risk of water shortage is increased by climate change, cases about the failure to comply with the forest code. And these cases, they do not expressly mention climate change, but they consider, for example, the harmonious coexistence of the forest system with the related systems like the climate one. Cases that discuss the unconstitutionality of the forest code, they mention, for example, that climate change is increased by illegal deforestation. Is it possible to see a significant change in most recent cases profile? These recent cases mobilize, both in the petitions and the decisions, laws and facts relating to climate change in a more explicit, direct, and central way, although they still come together with other environmental themes. It's also important to say that the setbacks and the dismantling of the Brazilian environmental policy occurred especially in the last 4 years, in addition to the climate emergency itself, drove the focus to climate issues in Brazil, bolstering the climate litigation movement here. Then these recent cases, differently from the previous ones, were filed with this purpose of protecting climate stability. And here, and in the next four slides, we can see a few examples of some of the more recent climate cases in Brazil. They are different kinds of cases that deal with civil liability for climate change damage caused by the steel industry, for example, public civil action that questions the growing curve of deforestation in the Amazon, and constitutional cases, some of them very famous, got famous with the decision, like the case on the climate fund. So we have, this is something interesting to hear here. We have many constitutional cases that are related to the inaction of the federal government in combating the Amazon deforestation and implementing the climate policy. We also have climate cases that argues that we have the right to a stable climate as a fundamental right, as a human right, inherent to the right to an ecologically balanced environment. We have public civil actions about coal mining projects, and in all these actions, they allege flaws and insufficiencies in the environmental impact assessment of these projects. We have popular actions brought by citizens, and those actions, one of them question the adequacy of the regulations of a program called Incentive Auto Program. This is a program by São Paulo state that grants tax incentives to car assemblers. And what they say is that they do not respect international, federal, and state rules protecting the climate system. We also have, and I think Ana Carolina Haluk Bragança will probably talk about this environmental and climate damage cases resulting from the Amazon deforestation. There are at least 20 similar cases to the same area, and he was the one responsible for bringing those cases. So, and she's going to talk about civil liability for climate-related cases. So I think she might talk about those cases. We have one popular action questioning what we call here carbon trick maneuver. And this action argues that the regression of climate ambition in the Brazilian new NDC. We also have an interesting constitutional action that discusses the changes in the Brazilian energy planning, particularly in the provisions of mandatory contraction of energy from natural gas fired thermoelectric plants, which will increase GHG emissions, not complying with Paris Agreement and also Brazilian policies on climate change. We have another public civil actions that questioned the environmental licensing of the largest thermoelectric plant in the state of Rio Grande do Sul in Brazil. And they alleged the insufficiency of the environmental impact assessment and the need, and that might be aligned with the policy climate change and state policy on climate change too. There is also this public civil action filed by Observatório do Clima that aims to compel the federal government to update the national plan on climate change. And to finish, that's the last one with examples. We have some also interesting cases. One of them is against Brazil's Development Bank and the lack of rules for assessing the climate impacts of they say that the lack of rules of assessing the climate impacts of the bank investments violates Brazil's commitments under the Paris Agreement and also our national climate change policy. There is this public civil action that discusses the sale of carbon credits generated within extractive reserves. I don't know if it's the correct way to refer to these reserves, located in the Amazon. And this case argues that these extractive communities, they did not receive the proper compensation, although they have worked to preserve the forests in these project areas. And we have two constitutional cases related to just energy transition policies within the Santa Catarina state. And these cases argues the unconstitutionality of just energy transition policies, which provide subsidies to the use of coal for energy generation. Well, these cases cover a range of topics, as we could see, all of which are in some way directly related to climate change. They are, of course, in different stages. A few of them are already decided or are waiting for a final decision by the Court of Appeal. Others are still in course, waiting to be ruled for the first time. And although it's clear that climate change is specifically beginning to be fought in Brazilian courts, it's not yet possible to dissociate it from the environmental litigation itself. We can see that clearly when we try to answer the question of what climate litigation is in Brazil. Considering that there's no precise or just one definition to climate litigation, as Ivano was talking about earlier, we can say that climate litigation in Brazil fits within the broad concept of the movement in the Global South. Climate litigation here in Brazil encompasses direct and indirect cases in which climate appears as the central issue addressed, one of the main issue addressed, or as a peripheral argument. We have also systemic cases and routine cases. Both previous and recent climate cases converge in some way with the traditional environmental litigation cases in Brazil. And we can say that because, for example, the vast majority of Brazilian cases are based on the Article 225 of our Constitution. This article is the one that provides for a collective right to a balanced environment. It also imposes several duties to the government in order to guarantee the effectiveness of the collective right to the environment. So to discuss climate litigation in Brazil, we must consider these peculiarities, all the peculiarities of the Brazilian environmental legal system. And this is, in my opinion, very good news, as the environmental litigation can be seen as a shortcut. And we have the next slide, a shortcut for climate litigation here. Climate litigation in Brazil has its starting point and has as its starting points the successes of more than 40 years of development of our environmental law. Complexities and peculiarities of environmental issues, those super wicked problems that challenge the law, have already driven major changes in doctrine, legislation, and case law. And that's why I always say that, and to use the same word that Catalina used, environmental law is disruptive. So why don't we take these already paved legal avenues? Why don't we mobilize and improve already available and tested legal tools for protecting the climate stability? We do have what we can say a robust legal system applicable to environmental and climate issues. And we must consider especially the Brazilian federal constitution, our national environmental policy, our national climate change policy, and all the regulations regarding access to justice and diffuse rights protections, like the constitutional cases, the public civil action, and also the popular actions. In terms of constitutional grounds, we have already mentioned Article 225, which provides for a collective right to a balanced environment, and thus also to a stable climate as a human right. It's considered a fundamental right, as considered third generation human right. And here in Brazil, since 2019, our Supreme Court has recognized repeatedly this status of the right to the environment. So rights-based litigation is already seen here in Brazil in the domestic level for decades. Following what was already the inspiration for the national environmental policy, the environmental is protected from a systemic or a holistic approach in the Brazilian constitution. The environment protection got its own chapter in the Brazilian constitution, that specific chapter to protect the environment. And this chapter is considered the core of the environment protection in the constitution, but beyond that, the environment was also incorporated all along the constitutional text as a cross-cutting topic. For example, the chapter related to what we call economic order brings explicit reference to environment when it lists the environmental defense as one of the principles that guide Brazilian economic development. Justice Herman Benjamin, who has been playing a very, very important role in greening our High Court of Justice, says that, and I quote, that we went from misery to opulence in terms of constitutional protection of the environment. And I agree with him. On the other hand, we have the big challenge of putting in practice all these environmental regulations that we built since the beginning of the 80s. And it's still an enormous challenge, although we do see great improvements, especially in terms of the case law. Well, together with the Constitution, we have a national environmental policy and a national climate change policy. Our national environmental policy was enacted in 1981. It establishes a series of concepts, premises, and tools for protecting the environment. It was the first time in our regulation that we treated the environment, like we call it, as a whole. I don't know if it's correct to say that. Within a holistic or systemic approach, environment was no longer dealt or limited to these ecological elements, to air, fauna, flora, water, biodiversity, like they are not related to each other. The essential interconnections among these elements started to be considered by the law. In addition, social, economic, and cultural aspects are also part of the environmental concerns, according to our national environmental policy. All these new, not so new, but they were new back then, new concepts or the new way of seeing the environment within this holistic approach were included in the Brazilian national environmental policy, which provides important legal definitions for the understanding and enforcement of legal mechanisms for environmental protection and also for climate protection. Two of these tools are the environmental licensing process and the environmental impact assessment, which must take into account not only direct and short-term environmental impacts, but also the indirect and medium and long-term environmental consequences of the venture analyzed. Another important example that can be highlighted in the Brazilian National Environmental Policy is the provisions regarding the liability for environmental damage. And this provision says that this liability is strict, so it's applied regardless of fault on the part of the polluter, in addition to other many traits and disruptive traits that I don't have the time to explore now, but I'm sure that Ana Carolina will do that tomorrow. We also have a national climate change policy enacted in 2009. Although it's a policy directly dedicated to fighting climate change, its concepts, guidelines, objectives, and principles are intrinsically and explicitly connected to the whole environmental issue. Well, moving to the next part, to the Brazilian climate litigation profile, I would like to start saying that, as I said before, we launched this Brazilian climate litigation platform last August, and I must confess that building this database was really a challenge task, much more than I thought it would be. This database is dedicated to gathering information on Brazilian climate litigation cases, and I'm very happy with the partnership we have with the Sabin Center database and Grantham Institute database, and also the Latin American database hosted by AIDA. Well, the goal of this platform is to disseminate information that enables research and action to fight against environmental and climate injustices in Brazil. About this platform scope, it gathers cases filed before Brazilian courts and that relate directly to climate change. The climate approach in these cases can be the central issue, or one of the main issues addressed, or just a contextual argument, a peripheral argument. For the work to be feasible, we intentionally do not include indirect cases, although we understand their importance. The classifications in the platform aim to identify parameters that allow us to analyze climate litigation peculiarities in Brazil. We launched this platform with 56 cases, and now with 50 cases, sorry, and now we have 56 cases uploaded. We still have a few cases being analyzed to be included in the next weeks. Last October, we published the first bulletin, which systematizes the main quantitative results and presents an initial qualitative analysis of the data related to the first 50 cases. And although there is still a high concentration, this is the first analysis. Although there is still a high concentration of cases in the Global North, Sabin Center and the Grantham Institute databases and reports have warned that the number of cases in the Global South continues to grow. In Brazil, this trend can be seen in a sparse case load at first, and the recent increase in the number of cases. This increase in climate litigation in Brazil starting in 2019 can be for sure interpreted as a response to the social environmental setbacks promoted by the last federal government. In terms of who is fostering climate litigation in Brazil, the data revealed that the public prosecution offices as the leading actor responsible for presenting climate cases, with 9 lawsuits filed by the Federal Public Prosecutor's Office and 9 by the State Public Prosecutor's Office. And here we have also the organized civil society. It appears as a protagonist in the climate litigation movement, being responsible for 14 cases. And this is an interesting and new trend in Brazil, considering that NGOs did not used to act that much in traditional environmental litigations. We always had the public prosecution offices as almost the only one protagonist, the only actor that not the only, but we have had just a few lawsuits brought by NGOs. Well, considering now the defendant's profile, the vast majority of the cases are brought against federative units, public administration bodies, and state agencies. And this profile also confirms that increase in Brazilian climate litigation is related to the normal setbacks promoted in the last 4 years. In terms of climate litigation approach, although the climate litigation in Brazil began with general environmental cases that touched only superficially on the climate issue, we can say that the advance of the movement in the country has significantly increased the centrality of climate concern in these actions. Thus, today, the lawsuits that have climate as the main or one of the main issues constitute the majority, not the vast majority, but the majority of Brazilian cases. Most cases are classified as systemic cases, which shows a broad and strategic view of Brazilian climate litigation, in addition to confirming the need to fight the setbacks promoted by the last government. However, I agree with Catalina. Routine cases can also be very, very important, as they can be replicated in similar cases in the future. For example, the questioning before the courts of a specific projects that meet high levels of greenhouse gases. Those cases might foster changes in the sector, in a particular sector of the economy. The same way occur in terms of the cases related to climate impact assessment in the environmental licensing processes, or even to civil liability for climate-related damages. The next one, the vast majority of cases seek to contribute to the better regulation and implementation of climate protection. They are pro-climate actions. However, we can see that climate litigation can also be used as a tool for avoiding or questioning advances in climate action. For example, we have one case that questions the regulations relating to the reduction of the biodiesel mixture percentage in fossil diesel. They want to extend the time they have to change the mixture percentage of this fossil fuel. Addressing the climate issue is one of the most important classifications for us at JUMA. Justice is in our name, law, environment, and justice in the Anthropocene, the name of our research group. So we understand that climate justice is embedded in environmental justice as a specific issue within the broad scope of environmental justice. For us, both concepts allow for the assessment of how the issue of unequal distribution of burden and bonuses of climate change or other environmental impacts is being mobilized through climate litigation. So we have 6 cases that expressly mention environmental or climate justice. In these cases, the term environmental injustice or climate injustice appears explicitly in the action. In 13 cases, in the 13 cases that address the justice issue only implicitly, there is no express reference to the term. Still, the concept or the grounds of environmental and climate justice are discussed and used as a relevant foundation for the case. Finally, 31 cases do not address the topic related to these forms of justice. In terms of the biome, the Amazon is the protagonist biome in Brazilian climate litigation, being a relevant issue in 16 cases on the platform. The number of cases that expressly mention the biome reinforces the centrality of the Amazon forest for the climate and social environmental agenda in the country, and also the great challenges faced with the escalating deforestation in this biome. Half of the cases do not mention any biome as relevant to what is being questioned. Well, regarding the greenhouse gas emission sectors of the 50 cases cataloged until August 22, 25 deal with land use change and forest, followed by the energy sector with 18 cases. the large number of cases that deal with land use change and forest stands out, which reflects the emissions profile of the country. In 2021, 49% of the GHG emissions in Brazil were from land use change. And here we can see, that's the last one. Here we can see in terms of the measures addressed that the most requested one is mitigation, followed by climate risk assessment. And one of the trends expected for Brazilian climate litigation in terms of measures addressed is the growing number of cases related to civil liability, civil environmental liability for climate-related damage, and also climate risk analysis, also in climate licensing, in environmental licensing processes. Well, to finish, I would like to quickly reflect on some perspective for the climate litigation in Brazil in the near future, considering that the recent change in the federal government and the stoppage of the unedited wave of regression we faced in the last 4 years, we might see a reduction of systemic cases brought against the federal government. And in terms of who is going to be called upon, we'll probably see an increasing number of cases against the private sector. We might also see more routine cases related to the civil liability for environmental and climate-related damage, and to the consideration of the climate impacts in the environmental licensing processes. And to finish, the growing role of civil society in fighting the climate change here in Brazil will probably consolidate the involvement of NGOs in bringing new and innovative climate cases to our courts. So I think that's the 30 minutes. Thank you very much for your attention. I'm sorry again for my poor English, but I did my best here. And I'll be happy to chat about this after.
Thank you so much, Professor Moreira. It was a truly insightful perspective on climate litigation in Brazil, a perspective that, especially given the political changes in Brazil at the moment, has become a topic of discussion amongst climate litigants and climate lawyers across the world. So thank you for providing that overview and your insight and expertise. We would now like to move on to the final session of the day, which is a panel session on climate litigation and gender. This panel session will be provided by 3 experts in this field. Firstly, Dr. Dina Lupin, who is a lecturer at the University of Southampton in the United Kingdom and a director of the Global Network for the Study of Human Rights and the Environment, so GNHRE. Secondly, Ms. Natalia Ursula Gutierrez, who is a Chief Operating Officer at GNHRE. And lastly, Dr. Maria Antonia Tigre, who is an adjunct professor at the Elizabeth Hobbs School of Law at Pace University, a global climate litigation fellow at the Sabin Center for Climate Change Law at Columbia University in the United States, and the deputy director of the GNHRE. We thank you for taking the time to be with us today. We know, especially for the speakers that have presented in the earlier sessions as well, that you are presenting from the western side of the world, so are joining us at rather striking morning hours. But thank you for being here, and we really appreciate your expertise and taking the moment to share this with us. So over to you, Dr. Lupin.
Thank you, Larissa. I'm just going to share my screen. Sorry, just trying to get to slideshow. Okay. Hi, everybody. Thank you all for being here. Thank you so much for the invitation for us to be here. I am not presenting from 4 o'clock in the morning, but my colleague Natalia is, and I can assure you that she is just as coherent at 4 a.m. as she is at 4 p.m. So, but thank you, Natalia, for being here. So Larissa's already introduced us, so this is a little bit of repetition, but I'm going to do a little punt for the GNHRE because that's where we all come from, as well as our other kind of institutions educational affiliations, and it's where we all found each other. The GNHRE is a network of scholars and practitioners and activists and people working in all kinds of areas of life concerned with issues related to human rights and the environment. And we do lots of fun things together. We create lots of kind of opportunities and we like to platform interesting new research. So if you aren't a member of the GNHRE, if you don't know about us, please check us out and join if you'd be interested. So we're going to be talking about gender and climate litigation. There have been two kind of critically important developments in environmental and climate change law and policy in the last sort of couple of decades. One is a recognition at a growing level, particularly sort of by states and in the sort of international lawmaking sphere, that the kind of interconnected crises that we face today, not just the climate crisis, but the biodiversity crisis, are not just everyone's problem. So sort of a few years ago, the language of kind of a crisis for humanity or of the sort of common problem of climate change was very common. And there's been a sort of slow evolution away from that language, a slow appreciation that there's kind of really no such thing as a shared experience of biodiversity or climate crisis. Some people have less impact. They have played a smaller part in causing these crises. Those people also often have less say in how we address it today and what we do about it. And they face very different kinds of impacts in relation to those crises. Often it's a difference between inconvenience and existence. But the impacts of biodiversity and climate crisis is not something shared across humanity, even if all humans will be impacted. And this has become really integrated into our understandings of what climate change is and how our policies ought to respond to it. And in particular, there's been a recognition that the kinds of social and political and economic factors that shape so much of our lives, including race, gender, class, location, education, sexuality, ethnicity, disability, your occupation, all of these things make a hugely significant difference to the kinds of problem that these crises pose for you, but also a huge difference to what you can do about it. And with this growing awareness that that climate is not a singular homogeneous problem, there's been particular attention paid to the issue of gender and the impact of environmental harm on women and girls. And I would, and if you kind of look at the evolution of this in the international legal sphere, and this isn't really the focus of our paper, so I'm going over it very quickly, but there's been some great research on this. There's been two kind of key policy mechanisms that have developed around this, two responses to an absence of dealing with gender historically in international environmental and climate change law. One has been the development of the gender mainstreaming policy, which has been very influential, including for the IPCC. And the other is through the use of gender differentiated data. And this has been quite an important mechanism that's been developed by UN programs on gender and women, where they've sought to develop, categorize, collect data around the impacts on women and input that into the kind of policy-making processes that are happening in other parts of the world. So, first important development in the last few years, a recognition that climate and biodiversity crises are not something everyone experiences in the same way, with a particular focus on gender and the kind of increased vulnerabilities of women and girls. The other major development that we have been obviously talking about throughout the session has been the emergence of climate litigation as a kind of key phenomenon in the evolution of climate policy. And this is something that all the speakers before me have sort of pointed to And so I don't want to talk about this too much. Maria Antonia, unless you want to say something a little bit about the figures that we're looking at.
Sure, I can just briefly mention that this is part of our upcoming report for UNEP on the status of global climate litigation, which should be published in the next few weeks. And there were two previous reports, and that's why the images to the left are sort of the 2017 report, 2020 and 2022. So you can really see how there has been a constant rise in the number of cases, both within the United States, which was supposed, usually used to be about 80% of the cases. Now we're up to 70% of cases, but then at the global level, especially, that has increased a lot. And then one other thing that we tracked is the jurisdictions represented. So you can see that from the 2017 report was close to 30 jurisdictions, and then in 2020 we almost got to 40, and now it's around 65 jurisdictions. And that's, not only because obviously there have been more cases filed, but also because of the huge improvement in the data gathering process that we have at the Sabin Center's Global Climate Litigation Database. And that's, which I always like to it's a little bit off topic, but I always like to mention this because both Dina and Natalia and the researchers who work with Danielle also are all our rapporteurs at the Sabin Center, and they're volunteers who basically do a lot of the heavy lifting for us and let us know what's happening in their own jurisdictions. So that has really improved a lot, the data gathering, especially in the Global South. So I'll just mention this and go back to Dina.
Thanks, Maria Antonia. But I think what these show us is kind of the importance of the phenomenon of climate litigation. We've already heard in the talks today about the sort of range of climate cases, the sort of cases that get a lot of attention are seen as very significant or very centered on climate change, cases that are kind of get less attention or that treat climate change in a more kind of peripheral way. But I think what we are very clearly seeing is a kind of a whole is kind of the emergence of a whole new space of policy making, and that this isn't just important in the cases itself, but it's also important in the reporting on those cases and the kind of work that Maria Antonia is doing, the sort of recognition of the globality of this as a phenomenon, but also kind of bringing it to the attention of lawmakers and policymakers who begin to kind of engage with litigation as a kind of real factor in decision-making, policy-making, lawmaking at the domestic level, and we're now seeing kind of increasingly at the international level. So these are kind of two important developments that have happened in the area of international environmental and climate change law kind of in the last couple of decades, and two developments that I think have really sort of changed in quite substantial ways the frameworks and approaches within the field, particularly maybe at the international level, but certainly at the domestic level as well. We're rethinking the kind of how climate litigation, we're rethinking how climate change impacts us. We're understanding the kind of nuance and complexity of it, but we're also engaged in kind of new ideas and approaches to policymaking and lawmaking, and participation in policymaking and lawmaking around climate change. And I think we really see that in the litigation. But despite the fact that these kind of significant shifts have been sort of happening in parallel at the same time, we're not seeing an overlap between them. So what we're seeing instead is a bit of a gender gap in the climate cases. So despite this wide recognition of the gender dimensions of climate change, there are a very small number of climate cases that directly or even indirectly address the issue of gender and climate change. And so that's kind of what got us interested in this topic. That's what we're writing a paper on at the moment. And what we wanted to look at is how gender is or isn't dealt with in some of the cases, Maria Antonia's figures on the previous slide, and our speakers and the speakers in the session before this have pointed to the extraordinary number of cases. So obviously we're not doing a comprehensive review, but we're looking at a selection of cases to look at the way gender is engaged with. We're looking at the way in which gender is absent from these cases. And we're asking kind of, where do we go from here? And that's sort of what we're going to give you a bit of an introduction to today. I should say this is research in progress. We're working on this at the moment. And so we have maybe more questions than answers at this point, but I hope it's interesting for everyone to hear those questions and some of the ways we're thinking about addressing it. We've just before we get into the cases, which I think is the most interesting and exciting part of where we are at the moment, we've been thinking about a kind of framework for understanding gender in the climate cases. And so one of the things that the previous speakers have spoken about is that the ways in which cases speak about or address issues of climate change is not always front and center. It's not always the kind of the most prominent aspect of a case, that they can be kind of indirect climate cases. And we engage with gender in climate litigation in kind of a similar way. We're not just looking for cases that make gender and climate their sort of central concern. We recognize that that gender, just like climate change, might come up in litigation in kind of a wide variety of ways. And what we've sort of started to do recently is build a little framework around the UN Special Rapporteur on Human Rights and the Environment's latest report. It's a report that just came out, for those of you who haven't seen it already. It's a report on women, girls, and the right to a clean, healthy, and sustainable environment. It is quite uplifting reading because Boyd details good practice and examples of things kind of going right throughout the report. And so for those of you who need a happy read, I would really recommend it. But Boyd is also very realistic about kind of the limits of the extent to which gender is sort of adequately addressed in relation to human rights and the environment. But usefully, he starts off by identifying what he calls his 4 sort of central facts around gender and human rights and the environment. And we're kind of building from these central facts, because often what happens when there is talk about gender and climate change is there's a tendency to treat gender and climate change as kind of very flat. And the flat way in which it's treated is that it's treated as an issue of women and girls, sort of exclusively, first of all, and secondly, as an issue of kind of increased vulnerability. And there's been a lot of really excellent literature that's pointed out that the way in which gender has been integrated into a lot of environmental policy at the international and the domestic level is simply by treating women and girls as kind of quite passive victims of climate crisis, not as actors or agents, but just as kind of hapless, vulnerable victims. And that's an idea that's been really kind of challenged and problematized. And Boyd, I think, does something very useful in challenging that and in not centering vulnerability or victimization in his conception of the importance or the success of gender-based policies relating to human rights and the environment. So I'll just read them quickly. You can see them on the slide there. The first, when empowered to take action in defense of their human right to a healthy environment, women and girls have tremendous capacity and potential. When women and girls are intentionally, specifically, and equitably targeted by interventions as rights holders and equal partners, rather than being viewed and treated solely as vulnerable persons, environmental and climate actions are more likely to be effective and contribute to gender equality. The benefits of gender transformative environmental and climate interventions are experienced not only by women, girls, and gender diverse persons, but by all of humanity and nature as well. And because gender justice requires everyone's collaboration, educating and motivating men and boys to better appreciate women and girls' contributions and to become advocates is critical to gender transformative change. So Boyd kind of articulates an understanding of of kind of what is effective in addressing gender that doesn't center vulnerability, but rather centers agency, which we think is very kind of useful. But it also gives us kind of a range of sort of ideas of gender and the space of gender that we want to bring to these cases. So the idea of gender and agency is a very important part of that, but also of the ways in which gendered communities might be prevented from participating, the benefits of certain kind of participation, and so on. And so we've been working with these 4 central facts, and we've wanted to kind of develop them to build a framework for assessing the cases, but we adjust them in 2 sort of key respects. We think it's very useful that Boyd moves beyond vulnerability and kind of victimhood in his 4 facts, but we also think that the kind of differentiated impacts kind of disappear from the list. And so the fact that one's being gendered in certain ways changes your experience of climate change is no longer the only thing that's being said about gender, but it almost disappears from the 4 facts that David recognizes. So we want to bring that back in. We want to add the understanding of gendered impacts of environmental harm, but we want to be clear that understanding vulnerability is something we have to do through the kinds of claims, explanations, definitions, understandings that gendered people give of their own experiences. The other important difference that we want to add to this as a framework is that we don't really see the logic in carving out the kind of subgroup of women and girls. This has obviously been a long-standing practice of treating women and girls as kind of a special gendered group. We don't want to do that in our research. We don't think that that makes more sense than, for example, isolating groups in slightly different ways. For example, one might talk about racialized gendered groups or disabled gendered groups. We see those groups as all kind of equally legitimate, and women and girls is maybe too vast and varied a population to be useful for our analysis. So we want to talk about sort of all groups who are gendered in a way that results in their sort of oppression and exclusion, including gender diverse communities, trans communities, gender non-binary communities. And so we want to adjust Boyd's language slightly and focus instead on gender diversity or gendered communities. But that briefly is kind of the framework that we're bringing to our understanding and our analysis of the cases. So I'm going to hand over to Natalia now, who's going to talk about the cases.
Thank you, Dina. Yeah, so as Dina was mentioning, I will now talk about a few cases that we have been looking at. As Dina also mentioned, like this is by no means exhaustive, and it's pretty much a work in progress. But we do want to highlight some things that we have come across as we are researching this and like discussing the way gender is being dealt with or not in climate litigation. And apologies for my voice. It's already 5 a.m. here, but I'm not sure I'm as awake as Dina mentioned. But it's okay. So the first case that we wanted to talk about today is the Swiss case. I believe that this is one of the like most well-known or famous cases at the moment. But in case you haven't heard of it, this case deals with a group of senior women that filed a lawsuit against the Swiss government, and they argued that they, as a group of senior women, are especially vulnerable to heat waves that are the result of climate change, and that it is that positionality that gives them a particular like vulnerability that should be acknowledged by the government in their efforts against climate change. However, the Swiss Federal Administrative Court rejected the appeal. Well, the petition was initially dismissed, and then it was the appeal was rejected, and the court found that the women were not being exclusively affected by climate change, and therefore this reasoning obscured the differentiated impacts of climate change and failed to consider the causes that are behind this imbalance. In 2020, the Supreme Court rejected the appeal and held that the plaintiff's rights had not been affected with a sufficient intensity, and that the remedy should not be sought after by or through legal means, rather through political means. Next slide, Dina, please. So having exhausted all avenues at domestic level, the plaintiffs brought a complaint against the Swiss government at the European Court in what is known as the Klimaseniorinnen case. In this opportunity, plaintiffs again argued and focused on the material impacts of climate change on women over 75 years old, alleging that climate change will lead to more frequent and intense and prolonged periods of heat, and that this group of women have an increased risk of mortality in hot summers and are more severely affected by these rising temperatures. This case is still pending. The court held hearings and is expected to reach a decision in the late 2023 or early 2024. However, during the hearings, the gendered argument was touched. I mean, they touched upon that argument, but it wasn't like further explained or maybe like engaged with. So it's kind of like a missed opportunity there to provide a better explanation of what this is precisely, like taking into consideration how it came out in the domestic level. Next slide, please. In the next case that we are analyzing or like reading, it's the Maria Khan and others against Pakistan. And in this case was brought by a coalition of women that are arguing that climate change has a disproportionate impact on women, and that the government's climate inaction violates their rights to equal protection under the law and no discrimination on the basis of sex. In this case, gender is treated as a key determinant of the vulnerability of women against climate change, and they do mention relevant social norms that influence how this vulnerability and the effects of climate change are experienced in a differentiated way by women. So, for example, they mention that women tend to have fewer assets than men and that depend more on natural resources for their livelihoods. They also mention that when environmental disasters strike, women are more likely to suffer because of their limited access to financial, institutional, or social resources, and that social norms and ethos, such as dress codes that inhibit mobility, render them more susceptible to harms as a result of natural disasters. And the case is still pending, but we believe it's relevant and brings up very interesting arguments regarding gender and climate change. The next three cases that we're going to see today are being brought by children and are, as we will see, are focused on intergenerational equity and the rights of future generations mainly. So the first one is the one that was brought in Ecuador. And this case deals with the violation of the plaintiff's rights to live in a healthy and pollution-free environment In this case, plaintiffs are a group of girls, and they are arguing that the Ecuadorian government's authorization for the operation of glass fairs neglects the international commitments of Ecuador, including the Paris Agreement and the greenhouse gas emissions reduction commitments that the country has made. As I mentioned, this case is highly they focus on the argument of intergenerational equity. Plaintiffs are argued that children and newborns are at a higher health risk due to their close contact with nature, which is being polluted by the operations of the companies. The next case is one in Argentina, which is currently pending, but also presents arguments of human rights violations based on intergenerational equity and the rights of future generations due to environmental damage to some areas of environmental importance. Plaintiffs in this case also particularly refer to differentiated impacts on children and future generations that come as a result of the current activities that are affecting the environment and these especially environmentally significant areas, and that the failure of the government to protect these areas prevent their enjoyment of a healthy environment. And the third case that has been brought before the courts by children is Pandey v. India. And also although this case was initially dismissed, there's an appeal currently pending. In this case, the plaintiff argues that along with other children and future generations, she had the right to a healthy environment under the principle of intergenerational equity, and that the country's environmental law and public trust doctrine obliges the state to take measures to mitigate and adapt to climate change, and that it has not done so adequately. Plaintiff also argues that children are disproportionately affected and more vulnerable to impacts like heat waves, displacement, diseases, and malnutrition as a result of climate change. And finally, the other case that we wanted to highlight today is one that was filed by a group of indigenous women against the Ministry of Environment and others in Peru. And in this case, plaintiffs seek the protection of the river Marañón through the declaration of the river as a subject of rights. And petitioners in this case are asking for the recognition as guardians of the river, along with other indigenous communities of the area. This case, we believe, is one of the most interesting cases. However, is at a very early stage, and the information that is available to the public is very limited. But we believe that this case has or shows a lot of promise, as it deals with women, in this case, women at the forefront, and it deals also with traditional environmental knowledge and the role that these women play in passing on this traditional knowledge. So having talked about these few cases, these are some initial conclusions and findings that we are seeing as we go along in our research. So first of all, we see that women and girls are key actors in climate litigation and are bringing strong arguments to courts and acting as plaintiffs in what we believe can become landmark cases in climate change litigation and could influence climate governance. And in line with what Dina was talking about earlier and Boyd's report, the potential and capacity of empowered women and girls is huge. The role of women and girls as agents of change instead of mere victims or passive receivers of measures needs to be acknowledged, and we believe that's something that could be seen in climate as we discuss and problematize climate litigation. From our analysis, we found that climate litigation has not engaged meaningfully with the analysis of the differentiated impact of climate change on gender disempowered groups. Cases like the Clima-Signorinen case support their arguments on part on this, but it was still not recognized by the Swiss court. And as Dina also mentioned earlier, we have found that when gendered people are not being treated as mere victims, their situatedness and vulnerable position is being ignored or not taken seriously. We also found that even though specific arguments that rely on gender differentiated impacts of climate change are limited, all these cases refer to gender issues, including those focused on intergenerational equity. Gender people are already involved in climate adaptation efforts and are also being impacted differently by the lack of natural resources, by climate-induced displacement, and in carrying future generations. And as such, also in line with Boyd's report, the impact of gender transformative environmental and climate intervention extends to all humanity and nature. And lastly, we found so far 0 cases engaging with non-binary or gender diverse community, an aspect that we believe warrants particular attention and should be studied further. So now I hand it over to Maria Antonia.
Thank you so much, Natalia. All right, so after that initial analysis of the cases that do have some gender aspects to them, and looking a little more closely at sort of what the arguments as well were brought in terms of that gender perspective, we really do see that there's still limited engagement both by the plaintiffs and then by the judges when some decisions have been granted already with that gender aspect, even in the Clima-Signorinen cases, which is sort of the landmark case. From that perspective, there is still limited engagement with that argument. And obviously that's a significant gap that we're trying to highlight with this research, but that also provides an opportunity moving forward, and that's what we're trying to raise attention to and hopefully, clarify with for cases moving forward as well. So the opportunity for pending cases is that judges can actively engage with this gender argument by defining the vulnerabilities and the active role that these vulnerable groups can play in climate action. So like Dina mentioned before, moving from that discourse of women and girls as victims of the climate crisis, and really engaging with their active role in that. We do see a lot of examples of young women climate activists and who are really raising awareness to some of these problems, and some of them are bringing those cases, as you saw from the overview that Natalia gave. So there is really a big opportunity here from all of these cases that Natalia mentioned that are still pending to actively engage with that argument, rather than just, brush over them without really defining what those differentiated responsibilities of parties are towards them, and what the different roles is of the different stakeholders, and all of that, and sort of defining the human rights as well and how that is different. Then, Dina, if you can move to the next slide as well. And one of the opportunities that I really wanted to highlight here is the advisory opinion request on climate change that is currently pending at the Inter-American Court of Human Rights. I think you all probably know that we're really in a sort of a wave of advisory opinion requests on climate change, and one of those requests was presented by Chile and Colombia to the Inter-American Court earlier this year. And differently from the requests to the ICJ and to ITLOs, this one is actually a lot broader, and it has the questions. It's over 20 questions, and they really specify different types of human rights obligations and the differentiated impacts and obligations that states potentially have towards certain vulnerable groups, and that includes environmental defenders and indigenous groups. They specifically mention women as well as part of the question. So I'll just read it to you guys, some of the questions that do refer to women, and then I'll discuss it a little bit. But they ask for clarification on state obligations on the conventional obligations of protection and prevention for environmental and territorial defenders, as well as women, indigenous peoples, and Afro-descendant communities in the context of the climate emergency. And then they say, in accordance with the obligations arising from Articles 1.1 and 2 of the American Convention, and in light of Article 9 of the Escazú Agreement, what specific considerations should be taken into account to guarantee the right to defend a healthy environment and territory of women, human rights defenders in the context of the climate emergency. So, obviously, as you can see, that this linkage, like specifically defining the obligations towards women, human rights defenders, really embraces this perspective that we're pushing forward of their active role in defending their environment and their active role rather than as victims of this planetary emergency that we are facing. So they specifically ask the courts to define the obligations towards them as, within this perspective of active role rather than victims. So that obviously provides a very significant opportunity. The Inter-American Court has decades of jurisprudence of human rights protections, and since 2017, when there was another advisory opinion that recognized the right to a healthy environment as implicit under the American Convention. Ever since that happened, there has been a green shift, and there has been more opportunities and doors that opened up to engage with issues like climate change and biodiversity protection within the Inter-American Court as well. But that obviously goes on top of all of this rich human rights jurisprudence that has applied significantly to indigenous groups throughout the years, but also some other vulnerable communities. So we are hoping that actually the court will engage positively with this gender perspective in the advisory opinion as well. And that's expected to be, we're now currently in the phase of interventions on sort of amicus briefs. They don't call it that, but that is open to anyone who wants to engage with that process. It's really the most the court that has the broadest participatory rules, and they really are asking anyone who's interested to actually do engage with that and help the court with all of the necessary information to be able to provide an accurate response of that. And because they don't really have a lot of experience with climate change or any experience with climate change at all, they want that other organizations and individuals and professors to actually to engage with them and provide some information. So that's open now, and I wanted to highlight that as well. Then Tina, if you can move to the next one. So that's sort of the perspective for what's pending right now. But then one of the things that we also want to do, and again, I'll highlight that this is very, very early stages, and we really love your feedback as well, but is this question of how could gender-centered climate litigation find a platform, and if there are other avenues that could be searched to engage with that gender perspective. And one of the things that we've been seeing in sort of climate litigation movement generally is this engagement with human rights treaty bodies. So there's been, the Committee on the Rights of the Child has already been prompted to answer questions related to human rights obligations related to climate change, but towards children, of course. And then several other human rights bodies within the United Nations and at the regional levels around the world as well have been prompted to do that. And one of the ones that has not been prompted yet to answer any question related to climate change is the Committee on the Convention of Elimination of Discrimination Against Women. Hopefully I said that right, that correctly, but CEDAW, they have made certain statements in some of their documents related to climate change, but there hasn't been a specific complaint yet. And there is a complaint mechanism available that potentially could be leveraged to prompt them to engage with that discussion. And we identified sort of certain arguments that potentially could be raised, again, very early stages, but the right to equal protection under the law, which is protected under the Declaration of Human Rights, and many other human rights agreement includes equal protection under environmental and we argue potentially climate law. So that could be leveraged here. And then this whole issue of public participation in decision-making processes, ensuring that the policies are aimed at protecting the rights of women to health, property, and development, sex, desegregated data, and of environmental harm. So this issue of participation, which is also part of what the question that was asked to the Inter-American Court could potentially address as well, because they do mention the ASSELLAU agreement, which I think, as you all probably know, is an agreement that addresses procedural environmental harms and procedural environmental rights broadly, and there's several specific norms there that have been adopted recently that address this. And so combining that conversation of discrimination and equality with the procedural environmental rights is one potential avenue that could be followed here. And then, as Dina mentioned in the beginning, women who are particularly, there's some specific groups among this larger group of women and who are particularly vulnerable for various reasons, including because they're poor, older, disabled, and or of minority status, and that could give rise to additional protection. So having this gender responsive measures to climate change, so that would be sort of more in terms of the substantive environmental rights and human rights in general that are being potentially infringed here. And then the other thing that we wanted to mention, which is really sort of the beginning of a conversation that we're workshopping here, and we want to start bringing into the discussion is, as you know, the climate litigation in general has, we've been seeing a lot of cases that are being brought by children or youth or future generations who are sort of bringing those arguments in. And these are obviously different categories, and sometimes they're all mixed together, which is a whole other conversation. But that has, it's increasing a lot, and it's something that is getting a lot of traction across different jurisdictions. And obviously at the Committee on the Rights of the Child, it was the Saatchi case, and that prompted other conversations within the Committee on the Rights of the Child as well. So sort of in the indirect effects of climate litigation. But something that we have been thinking that is also missing is this connection between this discussion of future generations and in the gender argument and the role of women in all of that, because the health of women, and obviously climate change has some health effects as well, as we all know, but the health of women is really essential to ensure that there are future generations. So what we want to bring also in the conversation of this paper is, sorry, my kids are being really loud, so I hope you can't really hear them, but I'm almost done, is this idea of, that in order to have future generations, we need to protect these women that we have in the present, right? Because they will carry these children, they will breastfeed these children, and unless they are healthy and they have all of their human rights guarantees to be able to do that, there won't be any future generations. So this part of what we're identifying here in terms of the gaps is this disconnect between the future generations discussion related to climate change and the women and the gender conversation as well. So that's something that we are highlighting as both the gap and an opportunity, and something that we want to address here. So maybe I'll stop here, and really looking forward to your feedback and continued conversation, and to hearing your thoughts on all of this.
Thank you so much once again to Dr. Lupin, Ms. Natalia Gutierrez, and to Dr. Maria Antonia Tigre on their take, specifically in relation to climate litigation and gender, as another perspective on what we have heard, generally speaking, in climate litigation today. So before we move into our question and answer session, I'm just going to provide a brief summary of the 4 lecture sessions that we have just had, just so that we can all collect our thoughts and put back into perspective what we've learned from this morning's sessions, and then we'll open the floor for any questions. In the meantime, if you do have any questions, or you would like to pose your burning questions in person, please feel free to write them in the chat or to raise your hand, and we can get straight to you with our questions. So to start off the day's session, we had a presentation from Dr. Ivano Alogna, who presented on corporate climate litigation, new trends and directions. He spoke about climate change as the super wicked problem. He mentioned that climate litigation can affect the outcome and ambition of climate governance. He then went on to give a broad overview of climate litigation as it stands, with more than 2,000 cases, and with which has grown steadily over the last 20 years. He provided a definition of climate litigation, which is under debate, bringing to mind the narrow and broader definitions, but also looking at the vertical and horizontal litigation relationships. Ultimately, the correlations between fundamental human rights and the duty of care. He identified the 2 waves of corporate climate litigation, namely the 2000s to 2015 first wave and the 2016 to present second wave. He spoke about an extension of the second wave of corporate climate litigation to new areas, challenges, and creative ways of different causes of action and legal strategies. He gave an overview of the success of the Royal Dutch Shell case, as well as a number of key cases that have improved corporate climate litigation. We then had a presentation from Professor Catalina Piedrahita, who provided an overview of the 2 diverging perspectives on climate law and rights of nature. She spoke clearly about, firstly, the pessimistic view and the optimistic view, the latter of which we all hopefully seem to still hold. She went on to say that climate litigation emphasizes a duty of care, or a duty of governments and private actors to take adequate measures to enable to address climate-related harm. She mentioned the concept of butterfly politics, which we can all maybe understand from the basic concept of the butterfly effect, and this being applied to the consideration of climate governance broadly speaking, in that the routine decision-making that we have previously seen can have a major impact down the line. She spoke of the progresses in climate litigation, specifically the correlation between climate change and human rights. But additionally, she mentioned some shortcomings and ultimately the transformative nature of climate judging. We then had a presentation from Professor Danielle Moreira, who provided an overview of climate cases in Brazil and the state of climate litigation in Brazil. More specifically, she spoke about how environmental litigation was seen as a shortcut for climate litigation. And by shortcut, she meant the ability to mobilize and improve available and tested legal tools. She provided an oversight of climate litigation in Brazil as we see it, namely highlighting that Brazil is in fact a fertile ground for climate litigation. Then she went into depth on the Brazilian climate litigation platform and the various elements of that platform, for example, including the timeline of lawsuits, the types of plaintiffs and defendants, the climate approach, Brazilian biomes, and all of these being key considerations when looking at Brazilian climate litigation. And lastly, we had a presentation from Dr. Lupin, Ms. Ozula Gutierrez, and Dr. Maria Antonia Tigre, highlighting the correlations between gender and climate change litigation. Firstly, discussing the two critical impacts and developments in environmental and climate change law and policy, namely the social determinants of environmental cases, being the understanding of gender and the increased vulnerabilities of women, but also the understanding of the social, economic and political factors that make a difference as to how the crisis of climate change is experienced and the responses thereto. Secondly, the emergence of climate litigation and the evolution of climate policy, namely the globality of this problem and the attention to policy and decision makers. Ultimately, this panel discussion identified the gender gap in climate cases, and not only how we see gender, but also the acknowledgement of gendered groups and diverse gendered communities. We had an overview of the UN Human Rights Council's developments on women, girls, and the right to a clean, healthy, and sustainable environment. Speaking separately from this, we've now seen the development of the right to a healthy environment being acknowledged within the United Nations very recently. So we see this progress in the relation to women and girls as the next step in defining what this right would mean. We look at Boyd's central criteria, although this has been seen as beneficial in bringing steps to the right directions, there are specific gaps that has been identified in this panel session and brought forward by an adjusted framework that looks at the differentiated impacts of climate change on gender and gendered groups. And secondly, the identification of gender diversity and gendered communities. We had an overview of some key cases with regards to gender and climate litigation and an overview of the initial findings, as well as what's missing in the general debate on gender and climate change. So I hope with these key points and these considerations, we can all get back up to date with what we have seen and heard and listened to in the lecture sessions of this morning, and that we've had some very nuanced perspectives on climate litigation, broadly speaking, definitely doing justice to the topic of today being national and international climate litigation, individuals, states, companies, and nature. So I would now like to open up the floor for any questions. If you have any questions or any comments, if you would like to address any of our speakers directly, please be sure to raise your hand, or you can place a comment or a question in the chat function. Remember to either pose your question directly to myself or to everyone, and so that your question can be read out loud. I do have some, Carlotta, over to you first.
Now, please, if you have questions from the audience, go on. I can pose it afterwards.
Yeah, I think maybe I'll do one question from the audience and then we can go over to you and take it as such. So a question from the audience is, throughout the day, we've heard mention of a duty of standard of care imposed by governments and state actors. With the speakers that are still present, can we please have an understanding of what that duty of care is in relation to, for example, gender or to the rights of nature? So I'm not too sure who would like to answer this first. I'll go with the first in my line of sight. So Dr. Dina Lupin, if you would like to address this first, and then we can move on.
So the question, just to clarify, is what the particular duty of care of states might be in relation to gender or rights of nature. So I think it would be different in relation to gender and rights of nature. So maybe I'll just speak about gender. I'm not sure that duty of care is the right framework for us to be thinking about in relation to gender. So there are sort of particularly articulated rights and rights obligations that states have, and those obligations have been, you find them both in sort of domestic jurisdictions and then of course in international law, and the rights of non-discrimination have obviously been a very sort of core part of our international human rights framework since sort of the very beginning of the evolution of that framework. And the talk of non-discrimination on the grounds of gender has in one form or another been there since very early on as well. Although sometimes the language of gender hasn't been there specifically. And interestingly enough, there was a kind of evolution away from talking just about women to talking about gender, as people realized that you've got to include men in your understanding of gender discrimination and how you address gender discrimination. And recently, a whole lot of states have been back to resisting the language of gender. They wanted to go back to the language of women, specifically because they want to resist notions of gender non-binary and gender diverse communities. Anyway, that's kind of all an aside, but this notion that states have kind of particular obligations of non-discrimination have been there for a very long time, predating sort of any mention of it in environmental and climate change law. But as these things have evolved at kind of the international level, there's been, you know, a lot of ignoring of gender issues for a very long time in climate, and particularly in the evolution of climate change law. And even though women's organizations were kind of knocking at the door from the very beginning, demanding greater attention to and participation of women, it took decades for states to start sort of paying attention to women and gender in relation to climate change. And since then, the kind of issue of what states' obligations are and how those obligations have to be articulated has been a sort of evolving picture a little bit. So I mentioned the gender mainstreaming policy. One of the things that has been kind of quite enthusiastically taken up is this idea of addressing the problem of a lack of women's representation in legal decision making and in institutions like the Intergovernmental Panel, and that's been quite a big priority. But there's also been a kind of string of instruments, and of course, as soon as I have to call it up to mind, the name of the agreement has gone out of my head. Can someone tell me? It's not Lima. There is an accord that particularly addresses gender and climate change and kind of the particular obligations of states related to that. But at the moment, they are relatively minimal. So they relate to data collection, participation, and attention to increased vulnerabilities. So certainly there is room for much more deeper, profound understanding of what the kind of gender obligations of states are in relation to climate change. And maybe I'll stop there and hand over to Catalina, perhaps to talk about rights of nature.
Thank you, Dean, and thank you for this wonderful question, really. So I never thought about it before, and there hasn't been any judicial case for sure that establishes the standard for a duty of care towards nature. So far, what we have with traditional environmental law is so the duty of care is to take care of the environment so that we don't run off resources for ourselves as humans, no? Like the traditional notion of sustainability, keeping resources so that we have enough for ourselves and for future generations. But then the new types of questions that rights of nature put forward are, okay, and what would be for example, the notion of dignity, dignity as the base of all human rights. What would be the dignity of nature? What would be that standard to care for the dignity of nature? And as far as I have learned from colleagues from Ecuador and Bolivia who have rights of nature in their constitution, they talk about protecting the intrinsic value of nature, ecosystems, animals, and in a way that we can protect the ecosystems, ecological cycles, and kind of to think about the health of these ecosystems, not only the possible harms to human health, that may be caused by environmental degradation, but the health of a tree, of a forest, of a river, right? And of animal species as well. So it would be really, truly wonderful for a court to handle such a question. And I think this is also very, very beautiful question for academics, no, for us to think about what would be the standard of care for nature. Yes.
Thank you so much, Dina and Catalina, for those answers. I think those were really up points that you put forward, and I think they cause us to think what we understand as academics and researchers as a duty of care within each of our respective fields of research. So, for example, with me in relation to the just energy transition, that duty of care is also extremely different to what you have previously mentioned. I'd now like to hand over to Carlotta for her questions and comments and any questions sent to her.
Thank you. Yeah, I think my question to Catalina connects to the previous question. So you had this contraposition in the presentation between spectacular strategy and non-spectacular strategy, right? And you were sort of advocating for a non-spectacular strategy as a way for transformation, for change. So I wonder whether in your view, the rights of nature, it seems to me to be a spectacular strategy at the moment because it's against the at least Western dominant culture, but of course this depends a lot on the context. I feel also sometimes that this might be a problem of like lost in translation problem. So already talking about rights of nature is a little confusing because it puts the spotlight on nature as something separated from us, whereas I really appreciate your phrasing of nature including us. So my question is whether you think that we could transform the idea behind rights of nature into a not so spectacular strategy to really induce this cultural change. That is, I think, what we are looking for also in litigation, but also obviously in other forms of political action. And I was really inspired from what you just said now, because I think we have used a lot of climate science to create a norm shift in climate change litigation. So using, again, biodiversity science, biology could be, and bringing this to court could be really a way to maybe induce this kind of shift. But I don't know, I want to hear your observation on this. And can I also pose a question to Natalia and Dina and Maria Antonia? Okay, so actually I have many questions and I think it's normal because this is a super novel topic. My first question is, why do you think that gender has been invisible in climate change cases? On the other hand, from your presentation, from your overview of cases, it seems that there is relatively more cases in Latin America from women. So also, this would be interesting to know, why do you think that's the case? And then the last question is about what climate litigation could achieve in terms of gender equality, or how it could be a mean to improve the material conditions of women. No? So there are causes that are independent from climate change, why women are more vulnerable than, or women or gender community are more vulnerable than others to climate change. It might be that they cannot access private property. It might be, as you said, dress code, norms, and so on and so forth. So my question would be if you think that climate litigation could be a way not only to recognize victimhood and gender impacts, but also to bring a change in this, or to make women agents of this change.
Good, Carlotta. Thank you for your question. So when I started thinking about spectacular and unspectacular cases, the reason behind this was not that I don't like spectacular cases, because they are so much fun. They have really very interesting and different arguments, legal arguments. And I think they put judges in difficult positions, which I also like, because we all should be in a difficult position right now. And we need to feel uncomfortable in order to think more innovatively, no? And we need to also see how many of the ways we have been using for legal argumentation are not really working for the new kinds of problems we have right now. And so we need to tweak and twist and add and change and look at very different ways. So I like spectacular cases. I really enjoy when a spectacular case is won or a case is won. And I'm very sad and frustrated when they are not won. Like I was, for example, living in Norway when the Norwegian climate case wasn't successful for petitioners, because I thought it was such a good argumentation. You know, I really admire the work of the NGOs bringing up the case. And it's very expensive to litigate environmental law in Norway. So managing all this, you know, like putting together so many forces, bringing together so many people, resources to be able to argue and bring this case, and also to appeal the case. It was very expensive, and the litigants didn't really know if it was even possible to get the money, to gather the money to litigate and to go on second instance. So I was very frustrated, and I was even a little bit mad at the judges for not being more open to new kinds of legal argumentation and not being open to judicial review of administrative decisions like licenses, and not considering that the courts are also part of the are also a democratic institution, not considering the power, the balance power among the branches of power. So I very much appreciate spectacular cases, and I think they are very important because they mobilize attention as well as argumentation. However, my point is, when I started doing research on this, I read some papers studying climate change litigation so far and analyzing the jurisprudence produced or the case law produced, and they said that the cases were not solved in any innovative way, that there was no climate change jurisprudence being created, that the arguments were all like environmental law arguments. And even though sometimes the cases were decided in favor of the petitioners who were claiming climate protection, they considered that there was nothing special happening. And I thought, wait a second, the fact that judges are not answering all cases or deciding all cases in like spectacular ways, and with this I mean, or I think about precedent-breaking ways, or creating a whole new, you know, line of argumentation or doctrine, legal doctrine. I thought maybe what is spectacular here is the fact that judges are handling these very controversial cases, these new claims, with old tools. No, so isn't it spectacular that judges are using old tools to lower the profile of cases and survive, you know, the massive criticism that comes also from the industry and from governmental actors who want inertia to continue? So I thought this is very interesting and kind of revolutionary. And I think also just legally is very interesting how we use tools that we already have for new problems, that we don't say, okay, because we don't have the tools, because we don't have a perfect treaty or a perfect national climate policy yet, then we cannot do anything. No, we can do things with whatever we have. So in that sense, I think looking at unspectacular cases is also very important, and maybe there is a lot of traction and change happening, no? And I really appreciate Australia's effort on changing environmental planning practices by bringing very small routinary cases, administrative law cases. But you're right. I think it's you highlight a very interesting point, that is that just by the fact that we have new climate cases, this is spectacular already. No, it doesn't matter how the profile of the case is. It's innovative, it's different, it's difficult, it's challenging, and in that sense is spectacular. And the same may happen with the rights of nature, just focusing on an expanded idea of dignity, that it's not exclusive to our individual aspect as humans, but it's collective, including the collective planet and other living beings and everything, is already challenging and spectacular. I think you're right. That's a big dilemma. That's a big dilemma. And with legal realism, we have learned that many times judges are limited or are under pressure when it comes to dealing with cases that are like borderline political, borderline, like philosophically one step ahead, and they don't really know what to do. And I think in the case of Norway, this may have happened. That is very, very distinct of the Norwegian legal culture, for judges never to intervene in anything that happens with Congress, with the parliament. While in Latin American courts, it's completely different. It's seen as very problematic, but judges don't intervene in political issues. So it depends a lot on the legal culture, but I think we can use all the strategies. For example, with two colleagues in Norway, we wrote a paper on the rights of nature in Norway, discussing if they should be or not be. And then the answer was, okay, Norway has a history of discussing political ecology, deep ecology. That's a concept of a Norwegian philosopher. And it's not that they don't care for nature or they don't see nature intrinsically valued, also for legal protection, but maybe the idea of nature having rights is too strange for the Norwegian legal culture. And then it could be more normal or accessible, or I don't know, direct for the Norwegian legal culture to talk about duties toward nature, even though it's of course two sides of the same coin, rights and duties, but maybe to talk more about our human duties towards nature in an expanded way, in a way that is a bit wider than the traditional environmental regulation. Carlota, but yeah, I agree with you and I see your point. I think it's just by bringing controversial themes or issues, cases become spectacular.
Natalia, do you want to answer some of these questions?
Sure, I can start, and then please chime in afterwards. Okay, so I'm gonna try to go over all your questions, Carlota, and but I will say that most of them I don't have like a definite answer to it, precisely because we're just like as we mentioned, like this is a work in progress. So there are a lot of things that still need to we still need to discuss and study. But going to your first question on why do we think that gender is invisible in climate litigation, I think it was I think this comes from I would like to say that this might be the result of strategic decision by plaintiffs, and like we've seen that climate litigation is still like a contested issue. It still has like a lot of, or it's still met with a lot of resistance from courts throughout the world. And I believe that plaintiffs might find a more or might feel more comfortable using arguments that have already been tried and tested and successful, or that might not pose like an additional layer of difficulty, if you can say that. So I think that might, I mean, and this is like from my precarious analysis so far, like I think that could influence why gender might not have been like a central or a key aspect in some of these lawsuits. And this is like on the side of the plaintiffs. Now, on the side of the courts, I do believe it might be like, again, we're dealing with a lot of issues that deal with a lot of uncertainty, and I guess that that also it's present in the reasoning of the courts, but also, and in this, I want to like focus on my experience as a Colombian woman, and most of like the courts are like the gender imbalance in courts is also present, and that might also be part of the issue on how or why gender is or is not being dealt with by the courts. I don't know, Dina or Maria Antonia, do you want to say something on this question?
I mean, I think that's absolutely right. I mean, maybe just to sort of agree and add to Natalia's first point that like there has tended to be like strong compartmentalization of issues in climate litigation. So things are treated as each kind of on their own. And I guess that is because they're charting new territory, trying to figure out what concepts mean. But, you know, one of the points that Maria Antonia was raising at the end of her part of the presentation was that we've seen a series of cases that deal with the rights of children and future generations. And that is like a profoundly gendered issue, right? And like profoundly gendered in a multiplicity of ways. And yet the kind of gender dimension of the rights of future generations hasn't come up. And that's kind of striking. And as Natalia says, it hasn't kind of really been argued by litigants, maybe because they don't want to muddy the waters, maybe because articulating rights of future generations feels kind of revolutionary and spectacular enough, to borrow Catalina's language. On the other hand, maybe it's because there's a tendency to be too kind of shuttered about these things. You know, we all live in the sort of very compartmentalized, siloed law that we're kind of working with. And so, you know, there is a convention and a body that looks at the rights of children, and a convention and a body that looks at the rights of women. And you know, so partially I think it's a failure to see that there is no climate change issue that isn't also kind of a gender issue. And I think one of the reasons why we think the Kukama case is going to be so fascinating is because it kind of brings in issues of rights of nature. It's about the kind of legal personhood of a river, right? But very much, but there's a kind of very strongly gendered dimension to that, and about the relationship between sort of women and the river. And it'll be interesting to see the extent to which that is kind of very explicitly sort of engaged with or articulated or not. Yeah.
If I can just briefly add something else, I think part of, you know, like looking a little beyond the gender argument, I think in, you know, giving a little bit of an observation of sort of the climate litigation movement in general and how it's been developed, and especially from that rights-based perspective, I think what we've been seeing is there, you know, we covered a lot of ground in the last, you know, few years, decade maybe, in advancing some of these obligations and responsibilities, right? And that has always been, or mostly has been, to trying to define these obligations towards people in general, obligations from states, obligations from corporations. And, you know, now there are several jurisdictions that have defined significantly what these obligations, what these human rights obligations are. And I think what we're moving towards now is to specifically looking at some of these vulnerable communities and the people who experience differentiated impacts of climate change, and what are the obligations towards them, and if that's different from the general obligations. So we've been seeing that for children. You know, I wrote an article recently about indigenous groups and how they have been you know, becoming sort of active plaintiffs in climate litigation as well, very slowly, very, you know, reduced numbers so far, but starting that movement. And that, you know, for children and for indigenous groups, they're obviously also leveraging, you know, like Dina mentioned, that fragmentation of international law and human rights law, and leveraging those different instruments within this whole context of climate change. And that's like how we're seeing this now move towards, you know, a gender analysis. You know, didn't talk about sort of disabled persons as well. There's like only one case related to that, but that's also another conversation using that disability law to leverage that as well. So like different groups and different sort of experiences and perspectives that will now, you know, will now hopefully start to define those differentiated obligations as well. So, you know, I think that's part of what we're trying to do here, you know, with the gendered argument specifically.
So, and now to answer your other questions, I think I'll do them like together. So like maybe we can continue with this. And I think your question on Latin America as having more cases is very interesting. It's a great question, actually. First of all, I wanted to say that what we provided today was like an overview. There are another like set of cases. There are more cases that also like sort of deal with gender. But from the ones that we have identified so far, it is like true that there's like more cases from Latin America. Like that said, we still have like research to do. We might come up with more cases in other parts of the world. But one thing that I believe might, I don't know, like might be behind the fact that nevertheless Latin America has a lot of cases in this regard, could be because most of these issues deal with the notion of climate justice. And in a recent article that Maria Antonia and I published, we talk about how Latin America is it's a fertile hub for climate litigation that has nevertheless been ignored at like to some point up until now. So we do believe there's like a lot there that's being done that might not fall within the traditional or dominant parameters of what climate litigation is defined as. And this relates to the notion of climate justice and how groups that are and have been affected in a disproportionate way by the devastating effects of climate change are bringing these cases forward in these jurisdictions. And moving on to your last question on what we believe climate litigation could advance in terms of gender equality, like beyond the fact that they are bringing these cases. And you mentioned that these social norms and causes that are initially outside of climate change, I just wanted to mention that although it is true that some of these causes of gender inequality predate our current climate crisis, they are hidden by climate change. And they are exacerbated in the midst of our climate crisis. And understanding how this both like climate change and all these social and socioeconomic circumstances interplay will give us a more comprehensive account of what climate change or how climate change is being experienced by all humanity, and how this interconnection might affect the efficacy of measures against climate change. And finally, I think there's an important aspect to consider when it comes to knowledge production with regards to climate change, and how it is already being produced by gender groups, by marginalized groups, but by groups that have been historically excluded from decision-making spaces. And I think that by focusing on these kind of issues, as Dina said, like not seeing them as independent from each other could help acknowledge this.
Thank you so much to Natalia, to Dina, Maria Antonia, and Catalina for providing your comments on and your responses to Carlotta's questions. I think this has sparked a bit of internal considerations for all of us regarding your various research fields. I do have one final question, and I think maybe if you could provide just some key insights. It's more of a practical question. One of our PhD candidates has actually posted a practical question about the realities of your research methodology or your research design and methodology. They have stated that understanding and conceptualizing each of your respective fields in relation to climate change is both extensive and nuanced. Can you provide some key insights on how you have formulated your research design and methodology, especially for those initially pursuing their PhDs? So it's a bit more of a practical question, and especially considering that if looking at gender and climate change, it's a rather extensive, expansive, but also very nuanced topic. And also in relation to the rights of nature, we're seeing more and more literature coming up in terms of the rights of nature. And so if you could provide maybe 2 or 3 pointers for determining your research design and methodology, I think that would be really beneficial for our PhD candidates. So yeah, Dina, maybe over to you first. You're in my first line of sight.
Well, maybe, I mean, one thing that, so obviously we're working on this collaboratively, which makes it a little bit different. It's evolved in a slightly different way from the way a kind of independent research question would evolve or would emerge. But as we were preparing to present our work today, we were kind of very conscious that our research that is still in quite a sort of young stage, and we thought, well, you know, like maybe people would like to see us sort of at the initial stages, acknowledging a lot that we don't know where this is going and what it's going to look like, and so, you know, like part of the research process, I think, and something maybe you get more used to as you do it, is just kind of the possibility that something that you originally think you're going to look at and that you think might be interesting might not turn out to be what you look at, and might not turn out to be that interesting. You know, you've got to like flex and change. So we started off thinking about this project, our first kind of conceptualization of it, our first kind of description of it, and maybe just for a very pragmatic insight into working collectively, which again is very different from what you do on a PhD, but you know, as we've all done PhDs, and we know it can be a long and lonely slog. So finding opportunities to work with other people and to collaborate and to tell people about your work is kind of a very important part of that, I will say. But you know, like one of the things that when we first sort of started talking about it, we articulated this project quite differently, and we were sort of wanting to, it was a very sort of theory heavy project that we were thinking about. We were drawing on a philosophical tradition of feminist thought that I am interested in, and we were kind of really wanting to sort of grapple with the concept of gender itself, and try and think about what gender does or should mean in the context of kind of climate policy making, climate litigation. And so the project has kind of evolved a lot, which is also part of the reason it's, you know, still at a young stage, because each time we've gotten together to talk about it, we've understood what it is a little bit more. And the other thing that happens is that we kind of came to the subject thinking sort of very little has been written about this or thought about this. And, you know, we did a little bit of a literature review, and, you know, both Natalia and Maria Antonia are very like deeply kind of embedded in the cases that are coming out all the time. And so they're really seeing what's happening in real time. And we were very in there, you know, like we really felt like this was a very kind of untouched field. And of course, since then, everywhere we turn, we see gender and climate change or gender and climate litigation, all of which is kind of encouraging, actually. Although we're not breaking new ground, it feels like we're talking about something that people sort of care about. I mean, like that, none of that answers the question of kind of strategy and how one does it, except to say, you know, you do it piece by piece with a lot of kind of openness to this may not be what you end up writing about. And I think that's true when you work in a group, especially because we all bring our different minds and ideas to it every time. But I think it's also useful when you do something as an individual, you know, as someone who supervises people. I see sometimes people get very like tied down to an idea or a project or a, you know, like this is my question, I have to answer it. And I think that sort of just being open to the evolutive nature of research is always, I find it very relaxing to think this sort of has a life of its own and it'll go where it goes.
And if I can just add something to what Dina said briefly, you know, coming from like the beauty of what we're doing too is that each of us has different experiences and perspectives, right? Which is what Dina was talking about, sort of the collaboration of this. And because I manage the database, the climate litigation database, it's obviously sort of my day-to-day work and what I do and think about, you know, like 100% of my time. And, you know, it's great because I can have this macro vision, but it's sometimes like finding the different sort of trends within the cases is, I don't know, we can sort of get lost into that. And the reason why I started thinking more about this gender issue is as we were writing this UNEP report that's forthcoming, it was something that they flagged a lot because UNEP now has this gender, I don't know, like area, I don't know exactly what that's called. And it was part of the comments that we got back and say, where are the gender cases? Where are the gender cases? And I was trying to answer that question. And, you know, the conclusion that I have is that there actually are barely any gender cases. So then that's when I reached out to Dina and Natalia and said, you know, we should write about this because both of them have a lot more experience with that, you know, that argument than I do. But then obviously, you know, we're coming from from the database itself, right? And working with the database, which is, you know, very useful for anyone researching climate litigation. But the methodology in and of itself is also a little bit flawed because there are limitations to the database too, and there are, you know, cases that we miss, and the way that the searchability of the database works right now is imperfect because it just searches the summaries, and that's something that, you know, just flagging here that we are partnering with you know, a company that hopefully the idea is that we're going to be able to search the PDFs in the next, you know, 6 months to a year, and that's going to increase the, you know, the searchability enormously, and that we might find cases that we actually have not identified yet just because, you know, the way that the summaries were written, it doesn't flag that. So that's also something that people need to be mindful of. And, you know, whenever you're working, like students are working on their own research, I think it's important to flag those flaws, and that's not necessarily a problem, you know, it's just a limitation. And like being upfront about that is sort of the way to go. You don't need to, like, I used to get very stuck on like, it's not comprehensive, how do I know if I have everything? And, you know, and it's okay if you don't too.
Perfect. Natalia or Catalina, if you have any other comments that you would, Catalina, over to you.
Thank you, Larissa. Yes, I kind of need to go in about 2-3 minutes. So that's what I was raising my hand. But yeah, I really wanted to appreciate also the work that people like Maria Antonia is doing now with the database. So I was one of those people who used the database for my research. I started, I think, in 2015 using the database. So it was me and myself and I with my huge PhD project, which at the time felt like impossible. And, you know, and I really wanted to understand strategic litigation and cases in many cases, but of course, I didn't have the fun and really like review the documents, all the legal documents and everything. So having a resource like this public database or the Grantham Institute and the LSE database, or both combined, really, and there's so much work from so many people. I cannot imagine the amount of work that is, and I think it's a lot of voluntary work from people in different countries reporting on the cases and helping with the analysis and the summaries. And I really, you know, when I was alone with my PhD project, I was like so grateful for this, Maria Antonia. So thank you for also the work you're doing now. I think we are, you know, a big collective of people interested in these issues, and yes, so my besides gratitude is really use those resources that exist, because there's a lot of work behind them, and I think it's being done with a lot of care and responsibility. You can feel, no, like there is care in the analysis, in the also they openly and transparently say these are the limitations, it's not exhaustive, and all the legal all methodologies, research methodologies have limitations. So, and you know, I worked with this I defended my thesis in 2018. And I shared, you know, my methodology, and I said, okay, the limitations of using a database are this and this. Of course, I cannot assure all the cases are there. Of course, there might be biases, you know, like why we see so many cases from one continent and not from the other. But these are the limitations there are. And so this is how I worked with what I had. And, you know, my evaluator said, exactly, that's how it is. Yes. So use those resources. They're very, very good, excellent resources. And now that every year I see more and more, more and more people adding to the collective understanding of climate litigation, of gender issues, of rights of nature, indigenous rights. So use those resources creatively, and also, yes, collaboration with your peers, with your friends, with your colleagues. That is so important. Yeah, and the last bit could be just to strengthen what I said in my presentation. Don't fall into the tunnel of despair, which is difficult because we are studying things that are difficult and sad, and you know, you deal with these reports every day for, I don't know, 4 years of your PhD or 5 years of your life. It's hard, it's difficult. So also try to stay connected to all the creation that is happening, all the voluntary work, all the, you know, your colleagues, transparently, and also in solidarity, no, sharing their arguments, their ideas, yes, don't become egoistic with or, you know, wow, with these are ideas that we need to transform our collective action problem. It's also the way to academia with this kind of topic, but we shouldn't add to the same line of logic that brought us to the crisis, to multiple crises. I think we should be more open and also appreciate a lot the gender perspective on climate change research. I think it's been also very helpful for me. That will be it from my side.
Thanks so much, Catalina. Natalia, if you have any other comments or additions to add.
I just wanted to say, like I myself am at a very early stage in my doctoral program. I'm just gonna start it. But one thing that comes to my mind is just to be like patient with yourself and like take care of yourself, because I've heard that so many horror stories during PhDs, and I'm sure like everyone goes through so much at the same time while doing the PhD. So just wanted to highlight the importance of also like taking care of yourself and being patient.
Thanks so much for that, Natalia. And with that being said, it is with great pleasure that I once again say thank you to our speakers for taking the time to be with us for this morning's lecture session, and for this afternoon's lecture session. And thank you for the insights that you've given and for taking the time to also provide some comments and some key points on your research. Whether you're at the earliest stages of your research or whether you've been researching this for a number of years, any bit of your expertise and professional insight has given all of us something to think about and take home and apply to our own fields of research when dealing with climate change law and litigation. So we thank you again, and we really appreciate you joining us from corners of the globe and for being here at 4 a.m. to be with us and share with us, even though it's a little bit early for you. So we appreciate everything that you do, and we cannot wait to see the progress that you make in your fields. And I can speak for myself and for my colleague Carlotta, will definitely be following your research and supporting in the developments in your field. After, we're going to have a 10-minute break now, and then we will be pursuing our PhD candidate presentations, and we have 3 presentations also along the lines of climate law and climate litigation and rights to nature. So we hope that you will be able to join us, and we'll see you shortly after the break. The session will commence again at 15:55 p.m. so in exactly 10 minutes. Thank you once again, and see you after the break.
Thank you.
Thank you.
Thank you.
Thank you.
Bye.
Thank you. Bye.
Hello, everyone, and welcome back for the second half of our PhD workshop, and we'll be looking more closely now at the doctoral candidate presentations. It was originally envisioned that we would have one presentation and then a 10-minute question and answer session for each presenter, but I think maybe for today's session it would be better if we do all of the presentations and then have a group question and answer session together where we can go through some things relating to individual PhDs and just general PhD questions. So we have three presenters today, like I had said. The first presenter that we have is Ms. Inoko Krieniak. I think that's how you pronounce it. I'm really sorry. She's from the University of Miskolc in Hungary, and she will be presenting on the possibilities of climate litigation against carbon majors with regards to human rights arguments. Over to you, Inok. I think you should be able to share your screen and present.
Yes, thank you very much. Good afternoon, everyone, or good morning. I'm going to share my presentation now. I don't know whether it's visible.
Yes, it is, but it seems to be a little bit small. I'm not too sure if that will change when you...
Now, is it okay? I think for me it's the full screen.
It's still loading, but I think...
Or should I try again?
Yeah, you're more than welcome to try again. I think it's still... Carlotta, I don't know if you're seeing it still as like half screen.
Yeah, I mean, it's readable to the extent that you don't have a lot of text. Maybe it works also like that.
Okay. Ah, there we go. Full screen.
Is it better now? Okay, okay. So thank you very much, Larissa and Carlotta, once again. I'm very glad to have the opportunity to give a presentation today. And I'm going to talk about the possibilities of climate litigation against carbon majors with the special focus on human rights issues. So how to go to the next slide? I'm sorry.
I think if you click on the screen, it should... Ah, there we go.
Yeah, okay. So first of all, to put the topic a little bit in a context, I would like to talk about the business and the climate litigation in general. So we have heard by the lecturers today that the number of climate litigation cases is rising since the adoption of the Paris Agreement. And this agreement actually opened a new door for these climate cases. A special subcategory of these climate litigation cases is when the litigants use human rights arguments for various reasons. And the strongest reasons are possibly that there is a strong interconnection between human rights and climate change that is recognized not only by the scientific community, but also by several UN resolutions. So it is unquestionable that there is a connection. And another strong reason for using human rights arguments in climate litigation is the fact that in contrast to what the current regime of climate law or environmental law can offer, the human rights regimes offer sophisticated mechanisms to address violations of human rights. The majority of these climate cases are addressed against states. And actually, a very small amount of these cases, in comparison to the amount of the cases against states, are targeted against non-state actors. And the reason for this is very simple, is that it lies in the nature of international law and international human rights law. So it is binding on states and not on non-state actors such as corporations. But there is quite a controversy in this because non-state actors and corporations, some of them, especially the carbon majors, are largely responsible for the emissions that are leading to climate change. And then the question arises whether there is any possibility to hold these companies or carbon majors accountable for the human rights violations that lead to climate change, and if there is a possibility, then how? Under the current regime, business and human rights regime, it is covered by a soft law document that is the UN Guiding Principles on Business and Human Rights. So as I have mentioned, it is a soft law, and it has three pillars: state duty to protect, the corporate responsibility to respect, and the address to remedies. And in connection with this, I can also somehow perceive it from another side, which is the side of the state's positive obligations of human rights. So, for example, in connection with the right to property, it is the state's positive obligation to take the appropriate measures in order to prevent the harms caused by third parties that are, for example, private parties or companies. And there have been successful examples, a few of them, in the international sphere or also on domestic level, that could be cited. And the first one of them, which is probably the most important one, is the Milieu Defensie case against the Royal Dutch Shell, which was adopted by the Supreme Court of the Netherlands of The Hague. And I wouldn't like to go into the details of the case, just to mention a few key points that I identified which are relevant to this issue. Is first of all is that the court dealt with the question of the binding nature of the Paris Agreement, how it is binding on states and how it is binding on private actors. And the conclusion was that it's not binding to private actors, but what is really interesting from the court's reasoning is that there is an indirect effect of the Paris Agreement, an indirect influence of the goals of the Paris Agreement also on private actors, and that could be manifested in this duty of care, general standard of duty of care, because there is a consensus of the international community on the goals, what should be done in order to prevent the harms of climate change. And the court also dealt with the human rights obligations of corporations, that it is an issue and it should be addressed somehow. And another important initiative was the Carbon Majors Inquiry that is related to the Human Rights Commission of the Philippines. And in connection with this, a few key points is that the role and the power of human rights, domestic human rights institutions are really something that has potential, and they really should have an accentuated role against carbon majors, even if we are talking about an extraterritorial question. So the fact that it is a domestic institute, it should not hinder any endeavors to hold them accountable. And of course, this inquiry dealt with the accountability of carbon majors, accountability for human rights violations caused by the climate change. And there are several other pending cases, that is, for example, the Liuya case or the Total case, and the number of them are expected to rise in the future. And now I would like to identify some development directions that I found in this issue that would be interesting to deal with and to study more in the future. So first of all, there is an emerging need for establishing an accountability mechanisms also for non-state actors, because it is undeniable that human rights are violated as a result of the climate change, and that these non-state actors, these carbon majors, they contribute to the climate change. However, we could see that the current regime of businesses and human rights is based on soft law, but in my opinion, it could somehow lean towards the development of a customary law. So if there are more and more court decisions that are dealing with these issues, then somehow it can be channeled into the customary law of international law. And of course, I think more court decisions are needed, which deal with the interpretation of the Paris Agreement, as it was, for example, in the case of the Shell decision. Also because in the Paris Agreement, there is one reference in the preamble, even though it is the preamble, and it is again questionable how binding it is with regards to the other parts of the text of the convention. But there is reference in the preamble to governance and various other actors. And who are these various other actors? How are they how could they be channeled into these undertakings of the Paris Agreement. And the second key point, the second development direction that could be interesting is the strengthening role of national domestic human rights or even future generations institutions, as we could see from the example of the carbon majors inquiry. I come from Hungary, and we actually have a future generations ombudsman, which has the right, according to the law, to call upon an organization which pollutes the environment to seize this this activity, although it is not in the practice, it is not really used. But I think more and more of such organizations, such ombudspersons, commissions, etc., they could, with their good practices, they could somehow form the practice of this and to build up this approach from a bottom-up perspective. And thirdly, I think it is really for the future, because we know that there are a lot of pending cases before the European Court of Human Rights that deal with the issue of climate change. But I think it will be really interesting in the future to examine the influence of these decisions, which are, of course, they are against states. So if the European Court of Human Rights will adopt their decisions on climate change on states, then how it will influence the general thinking on climate litigation against private actors. And I hope that I'm in the time limit. That was all from my side, and I'm very grateful for your attention. Thank you very much. And of course, I'm open to questions.
Thank you so much for your presentation. As we said, we'll move on to the next presentation for now, and then we can have a general group question and answer session after we've finished everyone's presentation. So on to our next presenter for today's doctoral candidate presentation session, and that is Ms. Liane Baas, who is part of the Grotius Center for International Legal Studies at Leiden University in the Netherlands. She is also a research collaborator with the World Youth for Climate Justice, and we heard from Aditi yesterday about the work of the World Youth for Climate Justice. And she is presenting on her thesis, which is climate change litigation, following her research interests on climate change litigation and international human rights bodies. And she will be presenting today on climate change before international human rights courts and bodies towards procedural justice. Over to you, Liane.
Yes, thank you so much, Larissa. I will share my screen and then go for it. Can you see my screen?
Yes, we can.
Okay, perfect. Well, thank you. My name is Liane, and I am a PhD candidate at Leiden University, and I focus on climate change litigation in the international human rights sphere. And it will be my pleasure today to talk to you about it. So I'd like to start with this quote from Philip Sands from 2016, which says, "In our world, amidst the warming of the atmosphere and the melting of the seas and the rising of the melting of the ice and the rising of the seas, the international courts shall not be silent." And I think Philip Sands here gives a very adequate view of the current international legal landscape, because this link between human rights and climate change has been firmly established over the past few years. And that is why we're now seeing a development in international climate change litigation, and specifically in human rights courts and bodies. So my research focuses on this new development, these new cases we're seeing, and specifically I look into the individual and collective complaints procedures. So not the advisory opinions, not interstate cases, although they might be super interesting. I only look when persons, groups, or NGOs are taking states to court. And what's often overlooked is that we first have an admissibility phase in these cases before we can go to the merits phase. So we can fantasize about what's coming out of it, and we can discuss all these grand ideas. But if we're not getting through the admissibility phase, if we're not taking these procedural hurdles, we'll never even get to a court judgment on the merits. And so that's why my research focuses on the procedural challenges that litigants encounter when you bring a climate lawsuit to an international human rights court or body. So the focus of my research is as follows. I look at this procedural phase, which I think in literature is a very underdeveloped and overlooked feature, even though it is quite necessary. And the second part is I do a court-centered study. So even though literature usually looks at the high-profile cases, or they pick, for example, Agenda out of it, or they pick the Torres Strait Islander case, because those are interesting cases. There's a lot to say about it. But I think a court-centered study gives the opportunity for a much more holistic approach that accounts for the diversity in international human rights bodies. Oh no. Okay, yeah. So what I do in my research is I look which procedural requirements might be hurdles for climate litigation, I identify them, and then I suggest potential refinements of how can we reform the system, or how can we reinterpret these procedural requirements so that they might actually be suitable for climate change litigation. And specifically, I look at these judicial bodies in the Council of Europe, the Organization of American States, and the African Union. So those are the regional systems with individual complaints mechanisms, and then the UN Human Rights Treaty bodies. And then the specific procedural requirements that I found that might be challenging for climate litigation are state jurisdiction, which I'm going to put aside for a moment because we're going to zoom into that later. Victim status, because although it is quite clear that people are going to be harmed from climate change, it has often not yet materialized. It's quite uncertain when it's going to happen or how exactly it's going to happen. So that might be difficult to prove you're a victim. Additionally, the exhaustion of domestic remedies might be challenging. We've seen this in the Sachi versus Argentina case, where if you challenge multiple countries, does that mean you have to go through the domestic court systems of each and every country before you can go to a subsidiary international mechanism? Might be quite challenging for climate change litigation as well. And lastly, not substantially the same as another international investigation. Now, we're not really seeing this one yet, but it's very possible that in the future, if regional cases get rejected on procedural grounds, they might go to universal human rights bodies or vice versa. And then it's very clear that they cannot be the exact same case. So this is sort of an overview of the whole research. And then I want to zoom in specifically to the requirement of state jurisdiction to sort of take you along. So state jurisdiction is a threshold criterion that connects the state to the rights holder. So it basically says states have obligations towards these people, but not to these people because they are not within their jurisdiction. And this comes back to the Latin maxim of impossibilium nullo obligatio est, which basically says you cannot have an obligation if it's impossible for you to do something about it. So states cannot violate human rights if they're not in a position to protect them. Now, in case law, this notion of state jurisdiction has been interpreted very territorially. And this paradigm underlying basically says that a state only has jurisdiction and therefore only has human rights obligations towards people within its own territory. And this is, of course, quite limiting, but in exceptional cases, the courts have recognized extraterritorial jurisdiction, so outside of your territory, only if there is control or power or authority over these people. And maybe you can already feel coming that this is quite challenging in climate litigation because by its very nature, climate change is transboundary. These greenhouse gases that we're emitting are not stopping at the national borders. They are definitely impacting human rights abroad as well. And so this threshold criterion is going to be hard to fulfill if you challenge in court any other state than the one you're resident of. Now, in case law, we're seeing it in several ways. So in the Council of Europe, we see this notion of state jurisdiction in the very first provision of the convention, and it's been developed in case law, which has been deemed by Judge Bonello a patchwork case law at best. So it's a very complex collection of cases, but generally there's two models, a spatial and a personal model. So either you have extraterritorial jurisdiction if you have control over the territory, or you have jurisdiction if you have control over the person, for example, through state agents. Generally required is this overall effective control. And now the case that I've mentioned below, or otherwise known as the Portuguese youth case, shows why this is difficult in the context of climate change litigation, because of course it's very feasible and following the territorial interpretation that Portugal has jurisdiction over these children that are suffering from climate change. However, could we really say that Latvia, for example, has jurisdiction over either these children or the territory of Portugal that they're living on? Probably not, but still the Latvian emissions could be harming those Portuguese youth. So you see here that there's sort of a discrepancy between the two. And the same is visible in the Organization of American States, where you again see this all the way in the first provision that there should be state jurisdiction. However, in case law, they've been a bit more expensive. They've been a bit more innovative, and they have found this third model of cause and effect jurisdiction, which basically means that if human rights violations are caused by activities under a state's jurisdiction, they also have extraterritorial jurisdiction if there was effective control. Now, this seems like a really good development and could definitely be helpful because you only have to have control over the activity rather than the person or the state. But still, this direct causal nexus can be very complicating because we all know how difficult causality can be in climate change. And we're hopefully going to see this at some point in the Arctic Athabascan petition, which has been pending since 2013, that has this extraterritorial element that the court or the commission could use to further develop this cause and effect model. And then lastly, in the African Union, there's no jurisdictional requirement stemming from the charter, but in case law, the Commission has said that they largely follow the model from the Council of Europe. So this spatio-personal dualism, and they require overall effective control. No climate cases have been communicated there yet, so we don't really know how it's going to play out. Now, I hope that sort of demonstrates the problem that we have, and then the potential refinements we could look at. First of all, human rights treaties are living instruments, also the procedural provisions. That means that the courts can interpret and reinterpret these provisions how they see fit. So it might be plausible that the courts all adopt this cause and effect model that could actually work for climate litigation, because the Committee on the Rights of the Child in Sochi has said that this might actually be the most suitable model and might actually have worked if that case had gone to the merits. The other option we have is adopting diagonal environmental rights. And this is a much more invasive option because it would mean amending the actual conventions and charters, which is obviously very politically challenging, but it would amend the vertical structure of human rights to be more of a diagonal structure. So it would give states obligations with regard to extraterritorial non-citizens. And this could all be guided by the Maastricht principles on the extraterritorial obligation of human rights in the area of economic, social, and cultural rights, which is an academic collection of how they see that could work, these extraterritorial obligations. These are the options that I see that could fix this problem or that could help us move forward. But as of now, we are stuck with this procedural phase that is not ideal for climate litigation. And therefore, I believe that as long as human rights law does not reassess the identification of duty bearers in a globalized world, it is currently falling short of safeguarding fundamental rights and freedoms. Thank you for your attention, and I'm happy to answer any questions afterwards.
Thanks so much, Leanne. Just to move straight on to our next presenter, our final presenter today for the doctoral candidate presentations is Mr. Mohammed Gholam Sawa, who is joining us from SOAS University of London in the United Kingdom. He is also a senior lecturer at the Department of Law at the University of Dhaka in Bangladesh, and the founding executive director of the Center for Law and Development. His thesis particularly focuses on the rights of nature to respond to the climate crisis. Over to you, Mr. Sawa.
Yeah, thank you, Larissa. Am I audible?
Yes, you are.
Yeah, thank you. So I do not have any presentation, but I still I'll present something. The topic which I will be talking about, as you said, in the rights of nature, in the context of climate litigation, and particularly highlighting the role of indigenous and local values. So I'll be talking about on 4 aspects, particularly why this rights of nature is important, why such an alternative paradigm is important in order to respond to the climate crisis that we are having. Number two is the how rights of nature is being framed in the legal system in the form of constitutional norms to climate litigation and other judicial decisions. And number three is basically what could be the possible impact of rights of nature-based climate litigation, because we see, I mean, climate litigation is being practiced in the form of human rights-based or corporate climate litigation. But my research basically will focusing on climate litigation, looking at rights of nature perspectives. And finally, I'll be exploring the role of indigenous and local values in order to effectively implement or localize the rights of nature framework that is being developed emergingly. First of all, why such an alternative paradigm is important? Because climate litigation alone, because we are again going to the same track of the failure of the modern environmental law. If we cannot change the fundamental weakness of what the international environmental law is facing, because the international environmental law is mostly based on the anthropocentric environmental law framework, which basically leads to the global climate crisis, including the warming, the global water crisis, emergency, ecological devastation. Because you see, the existing international environmental law framework fails to integrate the human systems of governance with the fundamental rules of the art system. What Thomas Berry has rightly observed that over the years, human development has exacerbated the degradation and the destruction of almost every aspects of the earth that basically triggered climate change. And he has, rightly identified development as equivalent to development destruction, since the development for humans in the industrial context was simultaneously devastation for the natural world. And what David Boyd in this regard has identified the relationship of the international environmental law and the exploitation of natural objects in three particular aspects of anthropocentrism. First of all, you see anthropocentrism, the widespread belief that makes basically human beings superior over the rest of the natural world. And number two is the considering nature as property and legitimate its misuse as human being considered fit and necessary. And number three is the pursuing limitless economic growth to fulfill the needs and desires of modern society. So these three aspects basically epitomize what we are, doing a development and which is being legitimized and justified by the existing international environmental law framework, which start from the Stockholm Conference, and we still see in the latest UNFCCC and the Paris Agreement. So after that, we will be my research will be looking into at how the growth-driven development, which is again a sustainable development. My research will reiterate again that how sustainable development is being framed again, considering the trends of anthropocentrism, which again promotes, extractive development at the cost of natural resources and destruction. It is being argued that sustainable development is an eco-political project, which might be neither sustainable nor developmental. It is basically a green trap, the economic and political project of sustainable degradation, which already we see in an unprecedented way across the world that basically leads to the climate crisis. This is number two. Number three is basically human rights to environment again is being recognized recently by the UNGA. But again, that also, this framing of human rights to nature is also again on, based on anthropocentric perception. Prioritizing the needs of the human being or the rights of the humans first, and then nature next. But while we are talking about rights of nature, we are definitely not opposing the human rights, but we are talking about that by giving nature or ecosystem as or by making them as rights holder, we are making the human responsible, or we are transforming the fundamental rules of the art system, and by reminding the obligations of human being towards nature. And the last one, why this paradigm is important, is the right to development, what has been framed again in the 1986 declaration. Again, I mean, right to development is promoting another kind of developmentalism that again is based on anthropocentrism, and at the same time promoting extractive development model. I mean, in a way, right to development is also promoting a right-based approach to ecological destruction, which is again, I mean, responsible for causing climate crisis. The second aspect of my, I mean, research is basically how rights of nature is being framed. I mean, across the world. I mean, there are so many initiatives. We see 300 legal initiatives across the world so far. And another study reports that as of January 2021, at least 178 legal provisions recognizing rights of nature have been incorporated in constitutions, laws, regulatory policies, and court rulings. I mean, but over the years, we have seen the trends of the rights of nature mostly on the rights model is basically recognized having unique substantive rights, including the right to exist, to maintain the functioning of ecosystem cycle, and to be restored and when damaged, among other rights. And the legal personhood model basically it says that legal personhood does not recognize unique substantive rights for ecosystem, but merely and extends to I mean, rights to them, and by making guardianship I mean, to represent the nature, as we have seen in the context of Bangladesh, Colombia, India, and New Zealand, how legal personhood model has been recognized and flourished. In terms of climate litigation, so my research will be focusing on climate litigation, not only which are related to the broad goals of emissions, because most of the cases climate litigation is focused on the broad goals of emissions reductions and the mitigation and the compensation for loss and damage. But we need to keep in mind that there are some cases also which are successfully litigated within the broader context of climate change and making significant contribution to the climate governance. For the purpose of my research, basically, climate litigation has been framed as a tool that facilitates to conceptualize growing environmental problems related, which either directly or indirectly to climate change at the local and the international levels. For example, we see in the context of Africa that climate litigation has been used as public interest litigation based on constitutional and general environmental law by non-state actors or environment in groups. And I mean, my research will add some case studies also, particularly three. One is based on Colombia, Piedrahita River and the Amazon forest. And this next, the second one is based on India, and the third one is based on Bangladesh. You see that the Bangladesh has also entered recognized rights of nature in the form of recognizing rights of rivers. Bangladesh is also a country which is facing unprecedented climate crisis. I mean, again, being influenced by the development model, which is extractive in nature and which is legitimized by the environmental law framework, which is mostly anthropocentric and facilitating the existing development model. But the court came up with a, landmark judgment to protect the rivers in Bangladesh by recognizing rivers as living entities and identifying a national or state body to speak on behalf of the nature, making it as a guardian. And in case of Colombia, also we have seen in case of Piedrahita River has been given legal personhood. At the same time, the indigenous and local communities are making the guardians of those rivers. But in Indian context, we see, though the court has assigned a national body to represent river, but the state body has declined to represent the rivers. I'll make a comparative perspectives, analyzing the impact of the climate litigation in these three particular cases. My last point of presentation today will be why I am focusing on the indigenous and local values to localize rights of nature with climate litigation. Because you see, in terms of framing guardianship in nature, Colombia and New Zealand, Ecuador, we see they have emphasized on the, indigenous perspectives and the local communities, because they have identified or framed the guardianship based on the perceptions, views, and cultural practices of indigenous and local people. But on the other hand, we see in the context of Bangladesh and India, the guardianship has been vested to the government body, which is again, in most of the cases we see is the perpetrator to cause environmental degradation or deliver, encroachment and pollution. So this again creates a real dilemma, again, making rights of nature framework into the same domain of, existing anthropocentric environmental law framework. So my emphasis will be that the rights of, if we really look into the localizing rights of nature, we need to focus on few things based on indigenous and local values, because indigenous cosmology holds more protective views than the others, and at the same time we see some indigenous conceptions in terms of Ecuador, we see VNVV, South African context we see Ubuntu, and some other radical ecological democracy. So this kind of indigenous and local values basically facilitate to take the local context into the global context, number one, and number two is basically these indigenous and local values is necessary to understand and implement the human nature relationships, and by making obviously human being as responsible towards nature. Indigenous value is important, again, for the co-management approach that is being reflected in Colombia and Ecuador. Community-led resilience, again, another aspect that can be, encapsulated with the help of indigenous values. The indigenous and local values also help to protect not only the indigenous rights, but also promote ecological sustainability. The criticism what I have done few minutes before against the existing environmental law framework. So indigenous perception will basically give a new form of way or a new form of approach that basically goes with the interdependent relationship between nature and human being. Lastly, there is obviously a challenge that whether indigenous perspective can be accommodated in a non-indigenous context. But my argument will be that we have seen in successful cases of Ecuador and Bolivia that indigenous perceptions can be utilized in a non-indigenous context, and it has also transformative potentials to influence the settler law and policy, and to remold, to reinterpret the existing legal system in the light of indigenous rights and values, and that will help to localize rights of nature-based climate litigation. Thank you so much for giving me the opportunity. I'll welcome obviously any questions over my presentation. Thank you again.
Thank you so much, Mohammed Kalam-Sawa, for your presentation. I would now that we've finished all of the doctoral presentations and that we've had what is admittedly a very brief overview of rather extensive research topics. So with that being said, we do acknowledge that your research could take more than a 10-minute presentation. So we do appreciate you providing a succinct overview of your research. So what I would do first is maybe between Carlotta and I'm not too sure. Carlotta, do you have any questions or comments? And maybe if we could move through our questions and
Larissa,
comments.
you're cutting. Your connection is interrupting. I don't know if it's only for me.
Okay. Is that a little bit better?
Is it just for me, or everybody can hear well? Can you talk again? I just stopped my video to maybe.
Okay, let me do the same. Can everybody hear me clearly now?
Yes.
Okay, perfect. Yeah, I think the connection is bad. We have some thunderstorms and rain on this side, so that could be it. So the way that I'm thinking we go about this first is to maybe just give some general comments on each of the presenters' presentations, one by one, and then we can go through some group considerations later. There were also some points that we had discussed when you submitted your abstracts in terms of challenges that you had faced in your PhD research. So we can discuss that as a group a little bit later. So what I will do is maybe first go through Eniko's presentation and some questions and considerations there, and then myself and Carlotta can give some comments and some perspectives from our side. For me personally, I was very interested at your review of the accountability mechanism. I think when it comes to corporate attribution, especially in relation to climate change litigation from a comparative perspective, the accountability mechanism is, in essence, the problem of corporate climate litigation. It's the link between attribution sciences and the development of the causality link between corporations, individual corporations, and their responsibilities in terms of climate protection. So I wanted to know, in your thesis, do you envision doing more research on establishing the causal link between corporations individually? Because I think that does have a huge impact on the development of corporate climate litigation, broadly speaking, and the possibilities to attribute specific emissions to corporations that have explicitly stated environmental protection or climate considerations within their corporate social responsibility or within their general company policy. So yeah, just that was my question for you. So will you be looking more closely at that causality link in terms of attribution science in corporate climate litigation?
Thank you. I'm not sure whether I have heard everything clearly. I'm sorry if I interrupted.
No, not at all. I'm not too sure. Is the signal still really bad?
It's not really bad, but at the end it was a bit interrupted. So maybe if you can write it down.
Yeah, sure.
Thank you very much for the comment. It's very variable, in fact. And well, the truth is that I have recently started researching on this topic because I started with the human right to a healthy environment and the questions in connection with that. And then I shifted towards this direction. So the corporate responsibility and accountability, because this is something that I think needs more research and maybe more legislation and court practice, I would say. So this is an interesting question, and I definitely think that I will go to this direction as well, the causality link. And I'm also thinking about somehow channeling the issue of greenwashing. But I can say that this is my second year of the PhD, so I'm not very well advanced, and I'm still looking for that very specific direction, but I think I will go on this way, on this line.
Okay, perfect. Yeah, Natalia, I see your raised hand. You, the floor is yours.
Yeah, I just wanted to say, so it was like very interesting to listen to your presentation, and I just wanted, actually, it's a comment, like maybe if like by listening to you, I thought that you might find it interesting to look into Brazil and how the climate litigation there has approached the obligations in the Paris Agreement with and link them to human rights arguments. I think you might find something interesting there to your research, as well as the request for advisory opinion that Maria Antonia mentioned during our presentation. Like that one is it's just a request as of now, but maybe like to keep an eye on how it progress within the Inter-American system. Because they also like there's like a very particular emphasis on like human rights arguments and carbon like major companies emitters. So I think that those two could be like useful for you, like maybe if you haven't like already looked at those.
Yeah, thank you very much. I was thinking about it, and actually I have mentioned it at the end of my presentation that I'm thinking about, but of course it's more for the future to see how these international, the development of the climate change law and litigation at the international level in every level of jurisdiction, so domestic level, regional level, also in the practice of the Inter-American Court of Human Rights, in the practice of the ICJ, that about this advisory opinion as well, European Court of Human Rights. So everything, all of these developments, how they will influence also the corporate behavior and also the practice of climate litigation. So yeah, it was very useful, your comment. Thank you very much.
Carlotta, do you have any comments or additions?
Yeah, I didn't really have a question, but I mean, since you're looking into how the climate litigation against state is affecting the climate litigation against private, I think it would be really, and there is a lot of climate litigation against states so far. I think it would be really useful for you to, identify clearly what are the main barriers to climate litigation against corporate actors in human rights-based climate change litigation, to then be able to select what cases might be more relevant for you, because otherwise it's really a lot of cases.
Yeah, sure. Thank you very much. Certainly, I have studied those cases, and I mean, cases against states. And I know that even that field is very, so it's under development. Let's say that there are some successes, there are some initiatives which are less successful in this sense. So I would say that the strong body of this climate litigation, even against states, is still developing, despite the fact that it is more regulated in the sense that there are human rights treaties, there are environmental treaties, of which the subjects are the states. So in theory, it might seem easier. I know that, and it has also been presented by Liane, that there are a lot of hurdles in climate litigation against states, and these hurdles are even more when we are talking about corporations.
Perfect. Thank you so much, Aniko. We will come back to you if we have any questions for you. I just briefly wanted to move over to Liane. Liane, when I was listening to your presentation, there was a lot of information that I definitely resonated with in terms of your research. But just for clarity first, before I ask any further questions, you mentioned specific judicial bodies, and you also mentioned some procedural requirements. Do you intend on looking in great detail into each of those judicial bodies and outlining each of those procedural requirements?
Yeah, that is the general idea. Yes.
Okay. The reason why I ask is with you briefly mentioning more specifically on jurisdiction and extraterritoriality, some people have written PhD topics on just that alone. So I fear that maybe you may have a lot more on your plate than you think about, because especially I do see your focus on more the procedural challenges and the admissibility requirements within each of those bodies and within those procedural requirements more specifically. But I think when you start to, for example, look into victim status, that in itself is a huge body of literature, and there are a number of cases focused on victim status additionally. So I just wanted to know, in terms of your research and in terms of narrowing down your field of view, how do you intend to do that? For the judicial bodies, for example, I can only speak more specifically to the African Union. There are a lot of instruments that speak to accessibility and to procedural integrity, so to say, but the implementation and execution of those agreements is not exactly up to par in terms of the African Union. So it would be, for example, you mentioning them, but then having no concrete examples. So I just wanted to know what your idea is for each of those and how you want to put it together, just so that you have a cohesive idea and that you're not overwhelmed by the expanse of research.
Well, I have to say, I just started my PhD a couple of months ago. I feel very overwhelmed. I think that's pretty normal at this stage. So it's definitely going to have to be narrowed down further. The idea is to not go extensively through all the requirements, but mainly focus on climate litigation in light of those requirements. So I do not by any means intend to bring up all of the scholarship on everything again, because as you say, that is both too much work and it has already been done by a lot greater scholars than I am. But I don't think it has been looked at in light specifically of climate change as much. And so I have already narrowed it down quite a bit, because I started with all of the procedural requirements existing and I only picked out those that might be constraining specifically climate litigation. But I'm definitely taking note of your advice. I'm going to see how I can narrow it down further. Thank you.
Yeah, no problem. I think, yeah, when, as you said, you're only in the beginning few months. I think we all remember the beginning few months. It is a lot of research, and when you find that golden thread, it'll all click into place. So yeah, I think that's perfectly fine. Carlotta, I don't know if you have any comments.
I'm just trying to start my video. We are in the same office, but seems like here it's okay, it's stable. So that you can see my empathic face while I ask you questions and you don't think that you don't take it as a personal criticism. My first doubt or question of understanding was about one of the first slides when you said that you will also focus, or no, you will not only focus on high-profile cases. But my question here is, how can cases brought before international courts not be high-profile cases? How do you understand high-profile cases? I think I never read actually a definition of high-profile cases, but I have an idea of them being the cases that gather more attention, want to be more disruptive, and so on. Also, you are comparing different regional systems. So do you have an interest in understanding if there is a system that is better than others, making this kind of evaluation at the end? And then, okay, among the procedural constraints, you identify direct remedies as well. I understand that you might be critical with regard to certain restricted interpretation of the victim status, as well as of extraterritoriality. But to me, intuitively, it seems like the exhaustion of domestic remedy is generally a very important constraint, actually, because it also gives legitimacy, to an international court decision. It gives the judges, national judges, the possibility to express themselves on a certain topic. So, and my question is, how do you see it is from a normative perspective? Do you think that there are cases where maybe these requirements where we should find an exception, for example, to this requirement? I think this could be very interesting, because I have not really heard a lot of people challenging this constraint, but maybe you have another kind of intuition in this regard. That's it.
Okay, thanks. Yeah, so as for your first question, aren't all the cases high profile? I guess they are to some extent, some certainly more than others. What I meant though is more so that current literature often takes a specific case and talks about that in depth, whereas my intent is more to look at it from a court-centered view. So I want to go through all of the courts instead of all of the cases, and I will refer to the cases where they are, obviously, where I can use them, but the structure of my research is more court focused. So I will go through the courts per requirement. As for the domestic exhaustion of domestic remedies, isn't that an important constraint? I think they're all important constraints. And it's definitely not my intention to say these are just hurdles that we have to jump or hoops that we have to go through. We just have to pass them or get rid of them to get to the merits. Obviously, there's a bit of activism in me, so I do hope we get to the merits at some point. But all of these procedural requirements are here for reasons, often very good reasons. And that's why I want to look at them in light of the rationale and see how we can take that rationale and use it for climate change. So if I may use the state jurisdiction example, the rationale behind it was you shouldn't make states have obligations when they're not able to influence the protection of human rights. And that's very true. However, with climate change, states are definitely able to influence the human rights of non-citizens or of people across the world. So you could still keep this rationale and interpret the requirement differently so that it actually better reflects the reasoning behind it or what states wanted from it. And so for domestic or exhaustion of domestic remedies, I haven't looked into that specifically, so I unfortunately cannot give as precise of an answer, but I'm assuming that there's very good reasons for it. And I want to just see if we can interpret those reasons and reflect them in a way that still promotes climate change litigation.
And then, sorry, Leanne, just to add on to that, I'm trying to wrap my head around how you could possibly address your thesis objectives in the fact of, so will you be utilizing, when you say you're doing a court-centered approach, so for example, if you look at the European Court of Human Rights, are you then going to look at the procedural requirements of the European Court of Human Rights in relation to climate change litigation? And then from there, use the different cases that are there as examples to highlight key points in those procedural requirements of that court.
Yeah, so the structure currently is to go by procedural requirements. So have a chapter on exhaustion of domestic remedies and then go through the different systems, see how the requirement has been interpreted in case law, how it would be a problem for climate change litigation, and how we could reinterpret it.
And then would you, in the introduction to each of those procedural requirements, are you going to look at the normative framework and the establishment of those procedural requirements as they stand? Because, I mean, all of those requirements do fall substance and have been created outside of the confines of climate change law. And although they are applied more recently in climate change law litigation as it stands, climate litigation is a fairly recent branch of litigation, and those procedural requirements have been established, you know, years and years ago at the establishment of these international courts. So are you going to do, in terms of, I wouldn't say legal history, that's a little bit too expansive, but in terms of understanding the basis of the normative foundations of that procedural requirement, is that something that's going to be included in your thesis? Or are you more saying that the normative framework has already been discussed, the definitions have already been provided, and this is how they are now applied within the context of climate change?
No, I think you very well made the point that I am trying to make across my PhD, that all of these treaties are a product of both their time and their place, especially in the regional treaties. But that doesn't mean they're set in stone now. These are all living instruments that can evolve with time, that can adapt to new challenges. And I just think climate change litigation is a new challenge that we could accommodate for, just as well as other types of litigation could be or could become in the future. Thank you.
Okay, perfect. Now to move on to our next presenter. Mohammed, I'm not too sure if you saw the question in the chat that was directed at you.
Yes, I have just noticed, yeah.
Okay, perfect.
Should I go with this response first?
Yes, I think so.
Okay, so thank you, Julian. It's a very intriguing question, I would say. Obviously, I mean, part of my research will be looking into the effectiveness. Obviously, at the end of the outcome, we'll be talking about the effectiveness. And thank you for sharing your, knowledge and views also about the Colombia Atratu River, because I have just started my research. It's in the early stage. I haven't even updated yet. So the information is obviously will be useful for my research also. You see why I'm looking at the rights of nature perspective. Obviously, there are some challenges and the possibilities of every perspective or every thesis that we are undertaking. The possibilities, what I have highlighted is that why we need to adapt an alternative paradigm that basically accommodate rights of nature along with the alternatives to development approaches. So if we can adapt rights of nature and alternatives to development approaches in a legal system, that we are arguing that, or my research will argue that in a way that will not only fundamentally transform the existing, formulation of anthropocentric environmental legal framework, but also provide a new ways of seeing or perceiving nature, but particularly the relationship between human being and nature, because unless and until we can change or transform that fundamental problem, the problems will remain there, and the climate crisis will not stop basically harming us. So this is one, and obviously, this could be the possibilities. I don't know. This will actually happen or not. The real challenges obviously is there in terms of, particularly you have rightly pointed out about the framing of guardianship. We see the framing of guardianship in terms of Colombia and New Zealand based on indigenous and local perspectives. They try to accommodate both the indigenous and local perspective based on open consultation with those people who belong to or who live on the bank of the rivers. So that makes more sense than the perception what is being done in India and Bangladesh. There is no consultation with the local communities. There is no consultation with the communities who live by the rivers, basically, or whose livelihoods depend on the rivers. So there is no consultation with those people. So I am arguing that consultation with those people can give us a new insight, but I haven't consulted yet. So I will definitely consult with those people. So, my my take will be that the consultation with those local people can give more pragmatic solution to protect the rivers than the existing traditional model of river conservation or river protection. So obviously the challenges is there in terms of framing also regarding the guardianship in terms of making rights of nature. And there are obviously arguments that rights of nature is still can be ended up in the same trap of the modern environmental law. Why the modern environmental law is failing. Obviously, these challenges are there. Thank you for the question, obviously.
Hi, Natalia, over to you.
Thank you. Yeah, this is also very interesting presentation. I think the approach that you're taking on discussing the very framework, anthropocentric framework, that it's currently in place, but that it's also within where the rights of nature have been implemented so far. I think it's very important to look into that, how rights of nature collide with that framework and what we should do or could do about that. And I also and would like to highlight the fact that you're talking about consulting with the indigenous and local communities, because one of the things that I was thinking about as I listened to your presentation and also following the question in the chat box was that there has been a lot of critiques on how the rights of nature in particular and other indigenous cosmogonies have been co-opted. And while apparently being inclusive and taken into consideration, they end up being shaped in a way that ends up not reflecting what those cosmogonies and those local communities' knowledge actually think of. And I think that comes from the very way in which these communities and the main like framework work in different ways. So I think it's very important that you're thinking about including them and consulting them. And my question in that regard would be like whether you're thinking how to make sure that you're not just seeing their knowledge and this consultation process as a way of like as seeing these communities as objects of your research, and rather that as agents that should be from the beginning of even your research question. And I say this because that's also like part of the critique that indigenous communities and local communities have been saying about how academia in particular like take on like their knowledge. And it's like whether they're just being like used or seen as an object and not as a subject that produces knowledge. Like I just wanted to ask that.
Thank you, Natalia. I mean, obviously, this is a brilliant intervention, I would say, and the suggestions and the questions, obviously, I'll be keep that in my mind in the future endeavors. Regarding the questions, obviously, I would love. I would like to treat them as subjects, not obviously as objects in terms of framing or getting their perceptions and the understanding or the cultural practices that we see. So in terms of extracting those or their perceptions, I will obviously I'll have a plan to make an historical analysis also, that how those knowledge, how those perceptions have also been treated, exploited over the years by the settlers. For example, in the context of Bangladesh, I belong to Bangladesh. So you see that how, there was perception that indigenous people hold more protective views than the settlers, right? I mean, that's the general perception. But in the recent years, you see in the context of Bangladesh that indigenous people are also, causing ecological destruction. They are also cutting trees. They are also making, ecology, for their livelihoods, and which is being obviously influenced by the settlers, but that the influencing process has not come in a in a single day. It has a process, a long historical process of exploitation over those people. So that kind of vicious process of exploitation that probably or could be propel them or compel them to go for exploitative models of living or development. That could be one way that I'll be planning to undertake in my research also. So that's the way I'll be looking into it, and will be adding that perception also, what is going on. I'm not sure again, even whether those people, which people I'm trying to consult with them, whether they can talk with me in an open mind. Because you see, not only they adapted the practices of the extractive practices, but also they have a fear also. There is there remains a culture of fear also over them. That makes a real a sense of scary, not to express their own or aboriginal thinking. So that there again, a challenge or limitation is there that I'm thinking or a bit worried that how I can overcome that challenge and deep into the research endeavor and to extract the opinion from them. The real or true sense of practices there. They belong or they had belong at one point. So my endeavor will be there. I can only hope for the best. Thank you for the intervention, Natalie.
At the risk of also putting forward some provocative statements here, Mohammed, in listening to your presentation, I do understand within the concept of sustainable development, when it was originally developed in the Brundtland report.
We can't hear you. We can hear very little.
Okay, is that better?
Yes, we can hear you now.
Okay, perfect.
Yes.
While I do understand, especially for me personally, I've also looked into sustainable development as a concept, more particularly in the context of ensuring a right to development. And I think when analyzing sustainable development, it's really important to be cautious of the understanding that the concept of sustainable development, as it was originally envisioned in the Brundtland report, was obviously developed as an anthropocentric term. With that being said, the original definition of sustainable development as defined in the Brundtland report was not outlined and was not provided for in the context of climate change. Because the Brundtland report was written in the 70s, and so the outcomes of sustainable development based on that was anthropocentric and was human driven, so to say. That doesn't mean that sustainable development in future is limited to what you have said.
I'm not sure if others are hearing Larissa.
Hello?
Yeah, better typing maybe.
Okay.
So far I can hear.
Yeah.
Can everybody hear Carlotta more clearly?
I'm sure. I think Larissa is speaking here.
Can you hear me?
Yes, I can hear.
Maybe you can come over.
Okay, so far I understand the question is that sustainable development is being framed in the Brundtland report in an anthropocentric way. So that's also my proposition, that sustainable development has been framed in the Brundtland report in an anthropocentric way that not only promotes development in an extractive way, but also legitimizes development that causes ecological destruction. So my proposition that sustainable development needs to be redrafted, reformulated with the more ecological perspectives. Because you see, sustainable development tries to make a balance between the present and the future generations, but how it will identify the needs of the human being, again, the needs of the human being is being prioritized in the concept of sustainable development rather than the preservation of environment or the conservation of ecological resources. The problem is there. The proposition is that it should be ecological sustainability rather than sustainable development, or the eco-development that we are proposing with the concept of, VNVV or the Andean communities. They see a life, where nature should get priority over development or over human needs. That's the life of the art system that we cannot cross the boundary, because there is a planetary boundary, there is art system. The art system is calling us to form a that kind of relationship, basically, that prioritize nature over human needs. And sustainable development currently is the opposite, because it prioritizes human needs over nature. So that kind of sustainable development is again followed by capitalism, Western modernity, colonialism. And I am proposing that sustainable development is again another kind of extractive developmentalism, or a tool of colonialism, to exploit natural resources, and that again creates a real tension for the developing countries also. Because that I mean in terms of climate change, we always talk about the ecological debts the developed nations should pay. But what are the reasons of those ecological devastation by the developed countries? Because of that sustainable development, or because of that kind of development they have promoted over the years. But sustainable development has been used to mask up or basically to shield or to justify development interventions. So my proposition would be to go for ecological sustainability based on indigenous based on indigenous perception that we have seen in the context of Buen Vivir and other Mother Earth or the Pachamama concept that we see in Ecuador and Bolivia. Thank you.
Perfect. Thanks so much, Mohammed, and thank you for the clarity there. I was, that's exactly what I have also done in my research, and I do have a shared vision with you to ensure the re-understanding and reinterpretation of sustainable development to bring it more in line with the needs of the present and with the needs of the future generations, as you've so aptly highlighted. If there are no more comments or questions or additions, I think we can close today's session. It has been an absolute privilege to host yet another day of the PhD workshop on climate law and litigation with all of you present. Thank you for those that have stayed until the end of this session, and thank you for the contributions that you've made and for your involvement in this workshop. I thank you to the PhD candidates and to our presenters as well for presenting your research and trusting us with your research, and for engaging with us and allowing us the opportunity to comment and provide oversight for you as well. We are a research community and we're all in this together, so this is not the end. We will be having a follow-up session with the PhD candidates to kind of provide updates on your research in 6 months' time, and also to be here as a platform for you guys to engage with and a sounding board for everybody to share their ideas and to engage more in-depthly as you continue with your research and pursue your research further. So for those of you that are here today, we hope that you will be able to join us again tomorrow for the next day's session of the PhD workshop on climate law and litigation. Tomorrow's topic is loss and damage, attribution, causation, compensation, and liability. And we will be hearing from some key experts in this field of climate law and litigation. Once again, I thank you. And just a reminder that you will be able to utilize the link that you have today for the sessions for the remainder of the week. And so we hope to see you once again. Have a great day, have a great evening, and we hope that you have enjoyed today's session just as much as we have. Thank you.
Thank you all.
Thank you all.
Thank you all.